Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and enjoy the show.
Yes, thank you.
Señora,
There is contact, Your Honor.
All right, sir, what is your name?
Augusto Contreras.
Augusto Contreras.
All right, sir, I'm going to go ahead and appoint the Office of the Public Defender to represent you. You're on 2 counts, 1 count of sexual battery, 1 count of battery. Court's reviewed the charging affidavit. He is entitled to a bond on count 1, correct?
Yes, Judge. It's F1.
This said bond on count 1 at $50,000. Set bond on count 2 at $500. Require, as a condition of your bond, that you have no contact with the alleged victim, that you possess no weapons, and you do not return to the scene where this is alleged to have occurred. So you're also out on bond in case 2022 CF 9497 AO. Court's going to revoke that bond and set bond at none. I'll appoint the Office of the Public Defender to represent you in that case as well. Thank you, sir.
Una pregunta.
I have a question.
Sir, I've appointed an attorney to represent you. You have the right to remain silent. Anything you say can and will be used against you. Given the nature of the allegations against you, it's probably a good idea to invoke that right. You have attorneys who can answer questions and file any appropriate motions. But we're done for today. Thank you, sir. Yep.
Advise the defendant that he has an immigration hold.
Okay. Sir, the pretrial release has asked me to advise you that you have an immigration hold, just so you're aware. Okay? Just for your knowledge. Okay.
Y en todo caso, ¿qué significa eso?
And what does that mean?
That'd be a question for your attorney. I don't know the nature of it other than there's a hold on you based on your immigration status. Okay. Thank you. Was there a victim here for that case? I don't know. They just brought them all in. Sorry. I mean, I don't know if it necessarily matters, but if there was, we'll bring them in. What was his last name?
Contreras.
Is there anyone here for Contreras?
And they may also speak Spanish. I don't know if the interpreter.
Can we ask in Spanish if there was someone here for Contreras?
¿Alguna de las personas que se encuentra aquí presentes está para el caso del señor Contreras?
Okay, seeing no hands. Can we ask if anyone in the box requires the services of the Spanish interpreter?
¿Alguna de las personas que se encuentra aquí presentes necesita los servicios del intérprete al español?
Okay. All right, let's go ahead and have those 2 people raise their right hand to be sworn in Spanish.
Estas personas, por favor, levanten la mano derecha para prestar juramento.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Juran y prometen decir la verdad, solamente la verdad y nada más que la verdad.
All right, thank you. Now
Gracias.
everyone else out there, please raise your right hand. I'm going to ask you the same question. Ask that you answer out loud. Do you solemnly swear, tell the truth, the whole truth, and nothing but the truth? All right, thank you. All right, next we have Layden Morales Lazar. Sir, what's your name?
Leiden Oviedo Morales Salazar.
Leiden Morales Salazar.
All right, this is case number 2020 CF 7430 AO. It's a warrant for a failure to appear. The bond amount was set at none. Court's going to stay the bond at none. Sorry, that was for Contreras. I'll appoint the Office of the Public Defender to represent you. Thank you, sir.
Was there a victim here for that case, Your Honor?
Is there anyone here for? Yeah, it's just a failure to appear, but I
Oh.
don't see one. Yeah. Okay. Thank you. Thank you, sir.
I didn't say it. There might be conditions previously, I don't know.
All right. Is anyone here for Cesar Angeles? All right. All right, sir, you can come up and put on the headset. All right, sir, what is your name?
César Ángeles Cornejo.
César Ángeles Cornejo.
All right, sir, you're here on one count of battery domestic violence. The court has reviewed the charging affidavit, does find there is probable cause. Court will set bond at $500 with the following conditions. You have no contact with the alleged victim. And no contact means no contact. No text messages, emails, contact through third parties. That you possess no weapons or ammunition. And that you do not return to the residence. You can return one time in the presence of law enforcement to retrieve any personal belongings. Other than that, you're not to return to the residence, okay? If I've not done so already, I'll appoint the Office of the Public Defender to represent you. Thank you. Have a good day. All right, ma'am, what is your name?
Elizabeth Jaime.
Elizabeth Jaime.
Is everyone here for this? Is everyone here for Miss Elizabeth? No, okay.
He's not. Oh, Your Honor, he said it's not the victim, it's the husband.
Okay. Well, he can just listen. All right, ma'am, you're here on one count of battery. Court does find it's domestic in nature.
¿Puedo responder?
May I answer?
Today, we're just determining conditions of release, which we're about to get to, okay? The court does find there's probable cause. The court will set bond at $500 in order that you have no contact with the alleged victim in this case. No contact means no contact. No text messaging, emails, social media, no contact through third parties. I'm also going to order that you consume no alcohol and that you possess no weapons.
Okay.
I'm also going to ask that you are required that you do not return to the residence where this was alleged to have occurred. If you need to return, you can return one time to the presence of law enforcement to get any personal belongings. Other than that, you cannot return to this residence. I'll appoint the Office of the Public Defender to represent you. If you do have a bond, you can bond out. There are those conditions which you must abide by until further order of the court. Okay? Thank you.
¿Puedo hablar? No puedo hablar.
May I speak?
I've appointed an attorney to represent you. You have the right to remain silent. Anything you say can and will be used against you. The only purpose of today's hearing is to set conditions of release. It's not to get into the truth, the veracity of the allegations in the complaint. It's usually a good idea to invoke your right to remain silent, especially when you have an attorney. Do you still have a question?
Hablaré con mi abogado. Gracias.
I will speak with my attorney. Thank you.
All right, good luck to you.
¿Esto es mío?
All right, sir, what's your name?
Hola. Oscar Orlando Arias Mejía.
Oscar Orlando Arias Mejía.
All right, sir, you're here on 2 counts. 1, possession of fentanyl. 1, no valid driver's license. Court's reviewed the affidavit, does find there is probable cause as to both counts. I'm going to appoint the Office of the Public Defender to represent you. I'm going to stay the bond on count 1 at 1,000. Stay the bond on count 2 at 150. Thank you, sir. All right.
Your Honor, the next defendant, the victim in Spanish.
The victim? Okay.
Victim that in Spanish.
All right. What's this young man's name?
Luis Machado Garcia.
Give me 1 second. Okay. All right, I think you heard, Madam Interpreter, but it's the victim in this case who needs the services of the interpreter. She is in the box.
Yes, Your Honor.
All right. And what is your name?
Señora, ¿cuál es su nombre completo?
Grecia de Los Ángeles, Angulo Romero.
Grecia de Los Ángeles, Angulo Romero.
All right, ma'am. Today's purpose of today's hearing is to determine conditions of release.
Señora, el propósito de la audiencia de hoy es determinar cuáles serán las condiciones de la puesta en libertad.
The court can put certain conditions, including that this young man have no contact with you.
Este juzgado puede imponer ciertas condiciones, las que incluyen que se le prohíba a este joven tener todo tipo de contacto con usted.
Or if you prefer to have contact, that we order he have no hostile contact with you.
Si usted prefiere tener contacto con él, podemos ordenar que se permita el contacto, pero sin hostilidad.
You can also order things like maintain separate residences, consume no alcohol, but we'll want to hear from you first.
También podemos prohibirles la convivencia, o prohibirle a él el consumo de alcohol, pero primero queremos escuchar de usted.
All right. So I've reviewed the arrest affidavit. I do find there is probable cause.
Habiendo repasado el documento acusatorio, determino que existen indicios de criminalidad.
He is entitled to a bond. Well, I'll just say that.
Él tiene derecho a fianza.
Are you currently afraid of him?
Señora, actualmente usted le teme a él?
No.
No.
Do you wish to have contact with him?
¿Usted desea tener contacto con él?
Sí.
Yes.
Do you two currently live together?
¿Ustedes conviven?
Sí.
Yes.
Does he have his own house?
¿Él tiene su propia casa?
Sí.
Yes.
Would you prefer me to order that you two maintain separate residences?
Señora, ¿usted preferiría que yo le ordene que cada cual viva en una casa aparte?
No.
No.
Okay. State, do you have any questions?
Le pregunto ahora a la fiscalía, ¿tiene alguna pregunta?
No, Your Honor.
No, su señoría.
One last question for you, ma'am.
Una última pregunta para usted, señora.
It's my understanding by reading the affidavit, there was alcohol involved in this, correct?
Señora, habiendo leído el documento acusatorio, creo que hubo alcohol involucrado en este incidente. ¿Eso es correcto?
Sí.
Yes.
All right, sir, I'm going to set bond.
Your Honor, I think he qualifies for pretrial
I
release.
just saw that. Sorry. Thank you.
Su señoría, yo creo que él cumple con los requisitos de libertad provisional. Sí, lo acabo de ver. Gracias.
You do qualify for pretrial release. That's a non-monetary release.
Señor, usted cumple con los requisitos para que se le conceda libertad a través del programa de libertad provisional. No tendrá que prestar fianza.
As conditions of your release, I'm going to require you have no hostile contact with the alleged victim.
Como condición de su puesta en libertad, señor, se le prohíbe el contacto hostil con la víctima.
That you possess no weapons or ammunition.
Se le prohíbe la tenencia de todo tipo de armas y municiones.
And that you consume no alcohol.
Y se le prohíbe el consumo de alcohol.
Anything further from state or defense?
¿Algo más de parte de la fiscalía o de la defensa?
Nothing from the state.
No, Your Honor.
Nada más de parte de la fiscalía, no, su señoría.
All right, thank you, sir, and thank you, ma'am.
Muchas gracias, señor y señora.
All right, who's the next?
Next one is Tia Torres.
All right, sir, what is your name?
Wilbert Santiago.
Do you understand English, or do we need the services of the Spanish interpreter for you?
Spanish preferred.
Spanish?
Yes.
Okay. All right, Madam Interpreter, the alleged victim in this case does request your services.
Okay.
Give me 1 second. Okay. All right, ma'am, what is your name?
Señora, ¿cuál es su nombre completo?
What's your name?
Tia Torres.
Tía Torres.
All right, Ms. Torres, you're here on one count of battery domestic violence.
Señora Torres, usted se encuentra aquí ante un cargo de acusación de agresión física por violencia doméstica.
I've reviewed the arrest affidavit. I do find there is probable cause.
Habiendo repasado el documento acusatorio, determinó que existen indicios de criminalidad
And that you qualify for pretrial release as well.
y que usted cumple con los requisitos para participar del programa de libertad provisional.
Pretrial release is a non-monetary release, but there's going to be certain conditions.
Este programa, para participar de este programa, usted no tendrá que pagar fianza para ser puesta en libertad, pero tendrá que cumplir con ciertas condiciones.
All right, sir, what is your name?
Wilbert.
Muy bien, señor, ¿cuál es su nombre?
Wilbert Santiago.
Wilbert Santiago.
Are you the alleged victim in this case?
¿Usted es la presunta víctima, señor?
Sí.
Yes.
All right, as a condition of Ms. Torres' release, we can order things like that she have no contact with you.
Como condición de la puesta en libertad de la señora Torres, nosotros podemos ordenar ciertas cosas como, por ejemplo, prohibirle el contacto con usted.
Or if you wish to have contact with her, we can order that you have no hostile contact.
O si usted prefiere tener contacto con ella, podemos ordenar que haya contacto pero sin hostilidad.
We can order that you maintain separate residences and things like that, okay? So I'm going to have some questions.
También podemos prohibirle la convivencia y cosas por el estilo. Así que le voy a hacer algunas preguntas a usted.
Okay.
Are you currently afraid of her at all?
Señor, ahora mismo usted le teme a ella.
No.
No.
Do you wish to have contact with her?
¿Usted desea tener contacto con ella?
Yes.
Do you two currently live together?
¿Ustedes ahora mismo conviven?
Sí.
Yes.
Do you wish to continue living with her, or do you want me to order you maintain separate residences?
Señor, ¿usted desea seguir conviviendo con ella o acaso prefiere que yo les prohíba que vivan en la misma casa?
Vivir con ella.
I would like to keep living with her.
Okay. Say anything, any questions for us, victim?
¿La fiscalía tiene alguna pregunta para la víctima?
Were your
No.
children present when this occurred?
Señor, ¿sus hijos estaban presentes cuando esto ocurrió?
Estaban dormidos.
They were sleeping.
I don't have any further questions, Judge.
Okay.
No tengo más preguntas, su señoría.
All right, ma'am. Well, you're going to be released as to this charge today on pretrial release.
Muy bien, señora, entonces usted será puesta en libertad por esta acusación el día de hoy a través del programa de libertad provisional.
Conditions of your release is that you have no hostile contact with the victim, alleged victim.
Como condición de su puesta en libertad, se le prohíbe el contacto hostil con la presunta víctima.
And that you possess no weapons or ammunition.
Se le prohíbe la tenencia de todo tipo de armas y armas de fuego.
Also see DCF was called, so as a condition of your release,
Así que entonces sí se llamó al Departamento de Niños y Familia como condición de su puesta en libertad.
just ask that you comply of any requirements that DCF may impose. There may not be any.
Tendrá, I'm sorry, Your Honor.
That's okay. I said that there may not be any, but, you know.
Tendrá usted que cumplir con todas las condiciones que imponga el Departamento de Niños y Familia si es que impone alguna. Puede ser que no lo haga.
And already appointed the PD, right?
Y ya he designado al abogado de oficio, ¿verdad?
If I will appoint the Office of the Public Defender to represent.
Se designa, señora, a la oficina del abogado de oficio para que la represente.
All right, good luck to you, ma'am. Mm-hmm.
Buena suerte, señora.
All right, that's it for the interpreter, I believe, correct? All right, thank you, Madam Interpreter. Have a nice day.
Thank you, Your Honor. You as well.
All right. All right, ma'am, what's your name?
Sheriff Northus.
All right, Ms. Norfus, I'm appointing the Office of the Public Defender to represent you. Looks like someone's come forward, so we're gonna wait for them to get in the box, okay? You're here on a warrant, so the probable cause determination.
Hello,
All right, sir, what's your name?
Kenneth Norfolk.
All right, what's your relationship to this young lady?
I'm her father.
All right, are you also the alleged victim in this case?
Yes.
Yeah, okay. All right, ma'am, the only thing we're doing here today is determining conditions of your release. Does she qualify for PTR?
Yes, Your Honor.
All right. You qualify for what's called pretrial release. That's a non-monetary release. In any domestic violence case, you're held no bond until first appearance. So that's why, that's all we're doing here today is making sure we keep any alleged victims safe. I understand every domestic violence charge is not created equal, but the state of Florida has done their best to keep victims safe in these situations. So, like I said,
And I,
they're not all created equal, but the way it works is that you're held no bond until we have
Right.
feedback from the victim and
Understand.
do all that, okay?
sir,
Yeah, and I'm gonna ask you some questions.
okay.
All right. Go ahead and say what you were gonna say.
I was saying, as far as the battery charge, it was minimal contact.
I understand.
And since then, I've had her evicted from my home. We had some problems, but I've had her evicted from my house, so I have no contact with her.
Okay, so she's not currently living in the home?
No,
All right.
Judge, I'm not sure if I saw him before. I don't know if he was sworn in or not.
Were you previously sworn?
no, I wasn't.
All right, please raise your right hand to be sworn. You solemnly swear the testimony you'll give today will be the truth, the whole truth, and nothing but the truth?
Yes.
All right.
Mhm.
Everything you said up until this point's been the truth?
Yes, sir.
All right.
Well,
So she's currently not living with you?
no,
She's living somewhere else?
yes.
All right. Do you, as a condition of her release, I can order that she not return to your residence if you want that. But that'll be a condition of release that she does come back. She'll be in
Well-
violation and could be picked up, but it's up to you.
Well, maybe in the future, I may let her come back. Like I said, we just had some little ups and downs as father and daughter does.
Okay.
And she's not really a bad girl, so.
All right. Well, I'll order that you maintain separate residences. Okay.
Okay.
So you can't live there, but she can come back if you want her to come back. Okay.
Okay.
All right. Hold on one second. I'm appointed the Office of the Public Defender to represent you, so you have an attorney. Anything you say can and will be used against you. I just want you to, listen, I'm just telling you for your benefit, all right? Today's not the day to really talk about the facts of what happened, the truth, that didn't happen that way or whatever. I have to take, there's already been a probable cause determination that an offense has been committed. So we're just determining conditions of release. You're gonna be released today as to this charge. We're just determining what appropriate conditions we're gonna impose, okay? So I really don't wanna know about the facts of what happened or maybe didn't happen, just knowing that what you say, might be used against you, okay? So I'm just telling you that for your benefit. Dad, is there any,
No,
was this particular incident for which the arrest warrant was issued, were any drugs, alcohol involved in that?
Not to my knowledge.
Okay. All right, ma'am. You're gonna be released as a pretrial release, so it's a non-monetary release. It's just a form of supervised release, so there's gonna be some conditions that you have to abide by, okay? I'm gonna order that you have, do you wanna have contact with her?
No, maybe not right now. I had her evicted, and
Let me tell you this, sir.
just as a punishment to her.
I can order that she have no contact with you,
Okay.
but if she does have contact with you in the future, she might be in violation of the court order and then might be held no bond.
Yeah.
Are you currently afraid of her?
No, not at all.
All right. I'm gonna order that you have no hostile contact with you, okay? And that means that, no arguing with your dad. Hostile contact means it's not physical. It's like if you start arguing and raising your voice and stuff like that's considered hostile contact, it'll be a violation of the conditions of your release and there's a chance she'll be brought back and might not be entitled to a bond at that point.
Okay.
So here's gonna be the conditions. I'm gonna order you have no hostile contact, with the alleged victim, that you two maintain separate residences. I'm not gonna order that you don't return, but it'd be a good idea not to return unless your dad says it's okay. That's not gonna be a part of the court's order, okay? The only part of the court's order is gonna be that you don't live there, that you maintain separate residence, okay?
Wonderful. That's great, sir.
Also gonna order that you possess no weapons, or ammunition. If you don't have any of that, that's fine, but, if you do have, weapons or ammunition, you need to surrender those to law enforcement within 24 hours of your release. If you don't have them, you don't have them, but as a condition of your release, you're not to possess any weapons or firearms, okay? Other than that, you'll be released as of this charge today, under those conditions, all right? Thank you, ma'am. Good luck to you. Good luck to you, sir.
Thank you so much.
Yep.
And Judge, for Mr. Aristil,
Mm-hmm.
I have a probable cause challenge.
All right. Okay, sir, what's your name?
Junior Aristill.
All right, Mr. Aristill, you're here on one count of trafficking in controlled substance, which I can't really pronounce, but, bond that came in is $50,000. I'm gonna appoint the Office of the Public Defender to represent you. She's indicated she has a probable cause challenge to, what's in the affidavit, so I'm gonna let her take it from here, okay?
Yes, sir.
All right.
So, Your Honor, he has been charged with trafficking in MDMA. Reviewing the arrest affidavit, it says that an officer Salazar located a gray in color wrapper containing 61 triangle-shaped pills that had the imprint of Tesla, and that they weighed 27 grams. However, there's nothing in the affidavit stating that they were field tested, so we have no idea what those actually are. And it also says that the contraband was submitted to FDLE Crime Lab for further processing, but they were never tested, so there's no probable cause to say that they were MDMA or that they were any other controlled substance.
State, did the officer say anything that he recognized them as MDMA?
He said he recognized them based on his training and experience.
Which paragraph did he say that? I believe you, I'm not seeing it right now.
The last paragraph on the first page of the narrative, the second to last paragraph, it says Officer Salazar, post Miranda.
Ecstasy pills, I see. Oh, no, hold on. Yeah, it's close, so I think that's enough just for the bare bones probable cause, that is, based on his experience, he says he recognized them as ecstasy. Whether they actually are or not, that'll be determined at a later date, but it's enough for probable cause. State, do you have a position as to the appropriate bond?
Judge, the state would just ask that you stay the bond at its current status.
All right, sir. The purpose of today's hearing is just to determine appropriate conditions of release and the appropriate bond, given the, and determine probable cause. The court's found there's probable cause, reviewed criminal history and the facts alleged in this affidavit. We're going to stay the bond at what it came in at $50,000. I've appointed the Office of the Public Defender to represent you. They can file any appropriate motions as it relates to your bond, okay?
Yes, sir.
All right, good luck to you, sir. All right, sir, what's your name?
Harold Willingham III.
All right, ma'am, what is your name?
Megan Thomas.
All right, you're the alleged victim in this case, ma'am?
Yes, sir.
All right, were you previously sworn? Did you raise your right hand to be sworn? All right. Do you swear the testimony you'll give here today will be the truth, the whole truth, nothing but the truth?
Yes, sir.
All right. All right, the purpose of today's hearing is to determine some conditions of release. You sat through a few of these, I think, so far, right?
No.
No, you just got here?
Yes.
Okay. All right, so I've reviewed the arrest affidavit. I'll appoint the Office of the Public Defender to represent you. You're here on one count of aggravated battery on a pregnant person. The court does find there's probable cause in the charging affidavit. He is entitled to a bond, or does he qualify for PTR? No.
He does not, Your Honor.
All right. So he's entitled to a bond, but we can impose some conditions on that bond, what it being, we can order him to have no contact, maintain separate residences. If you want to have contact and live together, we can order that he have no hostile contact. That means just no arguing, no raising your voice, things like that. We can, and so I'll ask you this, are you currently afraid of him?
No, sir.
All right. Do you guys have kids together?
Yes, we do.
How many?
One.
Were any of them present when this happened?
She was going down for bed in her room.
Okay. Was DCF called?
Yes.
All right. All right, I'll appoint the Office of the Public Defender to represent you. Do you currently want to have, contact with him?
Yes, sir.
All right. So you're not afraid of him, I think you said?
No, sir.
All right, and you currently live together?
Yes, sir.
Do you have any problem with him coming back to the house?
No, sir.
All right, sir, I do find there's probable cause. I'm gonna set bond at I'll set bond at $500. Order that you have no hostile contact with the alleged victim. That means no arguing. That's not just hands-on. That's, if things start to get heated and you raise your voice, that would be considered hostile contact. And if the police are called, there'll be violation of your release and you could be brought back and held no bond, just so you know, okay? Also order that you possess no weapons. For my review of the affidavit, I'll also order that you consume no alcohol. And the fact that DCF was called, I also require you to comply with any requirements imposed by DCF if they impose any, okay? All right. Is there anything further from State or Defense on this one?
No, Your Honor.
No, Your Honor.
All right. Thank you, sir. All right, sir, what is your name?
Charles Bellavia.
All right, sir, you're here on one count of battery, domestic violence. I'll appoint the Office of the Public Defender to represent you. I did review the arrest affidavit. Do find there is probable cause.
Your Honor, if
Yep.
I may, it says in his face sheet that he could qualify for PTR when APHIS clears. Would it be possible to order him to PTR?
I'd say out-of-state conviction for domestic battery. I'm not inclined to do pretrial release
Okay.
without a bond. How would we do that? Can I, if he qualifies, just, I mean, I'm gonna put a bond, but if he qualifies for pretrial release, I'm gonna give him a bond today. And we can do bond and PTR if he qualifies? All right, I think that may be beneficial too, okay? All right. So I'm set bond in your case of $500, okay? If you qualify for pretrial release, I'm gonna also order you on pretrial release. That's a form of supervised release. There's gonna be some conditions that you got to abide by. Because there's no victim here, I have to order that you have no contact with the alleged victim, okay? Also have to order that you do not return to this happened at I'm gonna order that you don't return to the restaurant where this is alleged to have occurred, right? It was a restaurant, right?
Yes, Judge, Star Bar.
All right. I'm also gonna order that, you can tell your attorney, do you and the alleged victim, were you residing together? Tell your attorney, I don't want you saying something that.
What was that? It was 500 plus PTR?
If he qualifies, yeah. Can we do that?
Your Honor, you can just place someone on PTR.
He qual,
It just be, yeah, because they left a note.
all right, so it's just PTR, apparently he does.
So you're doing 500 plus PTR? Or you're doing just PTR?
I think we'll just, if he qualifies, they're saying he qualified, we're just gonna do PTR.
No, it's still 500.
What?
All right, sir, you do qualify for what's called pretrial release. That's a non-monetary release, so you'll be released as to this charge today, but there's gonna be some supervision that you have no contact with the alleged victim. Counsel, did him and the alleged victim reside together?
Yes, Your Honor.
All right. I'm gonna order you not to return to the residence where you two reside together. If she's not here, I have to order it, okay? Because we have no input. Listen. These are conditions, so they're important. You can return one time with the presence of law enforcement to get any personal belongings, and then you have to maintain a separate residence. You can't go back there until further order of the court. You have an attorney represented to appoint you. If you want the court's order modified, there's appropriate motions that can be filed, but because she's not here, we have to order that you have no contact and that you do not return to the residence and that you maintain separate residence, okay? Again, you can go back one time with the presence of law enforcement. It's very important that you call law enforcement first. Don't show up and then call the cops, because then that'll be a violation of the court's order. You could be picked up. If you violate any of these conditions and are picked up, you can be brought back here and be held no bond, okay? So it's very important you follow the conditions, because it can have some serious consequences. Again, I'll order you possess no weapons. If you have any weapons, you need to surrender those to law enforcement within 24 hours of your release. Also order that you consume no alcohol, okay? All right.
And Your Honor, was that 500 and PTR or just straight PTR?
Now that he qualifies, it's gonna be straight PTR with those conditions. thank you. Mm. Oh, yeah, throw that away, sorry. All right, man, what's your name? All right, Ms. Karn. Sir, what is your name?
Tony Moore?
Tony Moore?
Yes, sir.
All right. All right, Mr. Moore, were you here, were you sworn in?
No, sir.
All right, please raise your right hand to be sworn. You swear or affirm the testimony you give here today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. All right, I don't know how long you've been here, so I'll give you the spiel too. The purpose of today's hearing is just to determine conditions of release. She qualifies for what's called pretrial release, which is a non-monetary release, so she's not gonna have to post a bond. You will be released as to this charge today. But it's a supervised release, so there's some conditions and rules that you're gonna have to, abide by, and we'll determine what appropriate conditions are. So thank you for being here, because that helps us determine appropriate conditions. You saw what happened to the gentleman before. Because the alleged victim's not here, I am required to order that they have no contact with each other. Because you're here, we can talk about that with you, okay? Are you currently scared of her?
Yes, sir.
All right. Do you two live together?
Yes, sir.
You have separate residences?
Yes, sir.
All right. Do you wish to have contact with her?
Yes.
All right. Do you mind it? Do you care if she comes to your house? I can order that she not come to your house if that's what you want.
I don't care. It's fine. She comes.
She can come to your house?
Yes, sir.
Do you want her to come to your house?
Yes, sir.
All right. All right, ma'am. You're here on one count of battery domestic violence. I've reviewed the affidavit, and I do find there is probable cause. I'm going to order that you have no hostile contact with Mr. Moore, okay? No hostile contact means no arguing. You have contact with him, but as soon as it turns into an argument and voices start getting raised and then that's considered hostile contact. If you have hostile contact with Mr. Moore, that could be a violation of your release, and you'd be picked up and held no bond, okay?
Yes, sir.
I'm also going to order, I'll ask Mr. Moore, was there any drugs, alcohol involved in this?
Yes, sir.
All right. Also ordered that you possess no weapons or ammunition. I believe that's it. State anything further as a condition?
Nothing for the state, Judge.
All right. All right, thank you, ma'am. You'll be released as it relates to this charge today with those conditions that we talked about, okay?
Thank you.
All right, good luck to you. Thank you, sir. What's that?
PTR?
Yeah. All right, ma'am, what's your name?
Irma Cortez.
All right, Ms. Cortez, I'll appoint the Office of the Public Defender to represent you. You're here on one count of battery domestic violence. I've reviewed the arrest affidavit. I do find there is probable cause. Because there's no victim here, I have to order that you have no contact with the alleged victim. Also I'm going to order that you do not return to the JW Marriott.
My car is there.
Okay, so I've appointed the Office of the Public Defender to represent you, but I see it as a hotel. I see that your address is in Margate. Is that where you currently live?
I live in Coconut Creek.
Okay. I'll allow you to return to the JW Marriott one time. I'm not going to require you to do it with law enforcement, but you can go back one time to get your car, any other things that may be in the room.
No, there's nothing. Everything's in my car.
Okay. So on that representation, you can go back and get your car one time. Other than that, do not return to the JW Marriott.
I'm going home.
All right. I also have to order that you have no contact with the alleged victim. I also have to order that you two maintain separate residences.
We live together.
You're not together?
No,
Okay.
we're not together.
All right, well then, no problem, for you, but it is gonna be in the order, okay? That you maintain separate residences, that you have no contact. No contact means no contact. It's no Facebook, Instagram, TikTok, through third parties, nothing, okay? If he calls the cops and say, hey, she's been contacting me through WhatsApp or whatever, then you could be picked up and brought back to Orange County and held no bond, okay?
What if he contacts me?
Ignore it.
Either or?
Call the police, ignore him.
Okay.
The court order applies to you, it doesn't apply to him. Okay? So if he shows up at your doorstep, don't answer it, call the police. You're to have no contact with him. You qualify for pretrial release as well, so we'll order you on pretrial release. That's a non-monetary release, so you'll be released as it relates to this charge today. Conditions of your release are the ones we've talked about. No contact, separate residences, and also that you produce no weapons, no return to the JW Marriott other than the one time to get your car, okay? All right, good luck to you. Mhm. All right, sir, what's your name? Oh, okay. Oh, sir, what is your name? Can you hear me? Sir, can you hear me?
Yes, sir. Yes,
All right. Sir, what's your name?
Jose.
De Leon?
Yes, Your Honor.
All right. So you're here on one count of battery domestic violence. I reviewed the affidavit. I do find there is probable cause. You do not qualify for the services of the public defender, but you do have the right to an attorney. If you want to hire one, you can do so. Set bond in your case.
I think he
Well,
qualifies.
yeah, you do qualify for pretrial release. That's a non-monetary release. So you will be released as it relates to this charge today. There's going to be certain conditions. You have no contact with the alleged victim in this case. I'm also going to order you have no contact with Mr. Darren Maxwell, okay? No contact means no contact.
Okay.
That's no Facebook, Instagram, TikTok, whatever other social media apps are out there, no contact. No contact through third parties. You can't tell someone else, hey, relay this message. If that happens, you'll be in violation of the conditions of your release and you can be picked up and held no bond, okay? You understand?
Understand, Judge.
All right. I'm also going to order you not to return to the scene where this is alleged to have occurred.
Understand.
And I'm also going to order that you possess no weapons or ammunition. You understand?
Understand, Judge.
Yep. If you do have any weapons,
No,
or,
Judge.
yeah, just if you do, I'm not saying you do, but if you do, I'm going to require you to surrender those to law enforcement within 24 hours. If you don't have any, it's fine. But if you do, you need to surrender those, okay? All right, but you'll be released as it relates to those charges today with those conditions. If you violate those conditions, you can be picked up and held no bond, just so you understand, okay?
Yes.
All right, good luck to you.
Thank you, sir.
Yep, thank you. All right, sir, what is your name?
My name is Clarence Freeland.
All right, Mr. Freeland, and ma'am, what is your name?
Jerusha Freeland.
Speaking to the microphone, I couldn't hear you.
Jerusha Freeland.
All right. What's your relationship to Mr. Clarence?
That's my husband.
All right. How long have you two been married?
Almost a year.
Okay. Were you previously sworn?
No.
All right. Will you raise your right hand to be sworn? Do you swear or affirm the testimony you give here today be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Everything you said up until this point, has that been the truth?
Yes.
All right. All right. I don't know how long you've been sitting out there, but the purpose of today's hearing is to determine some conditions of release. Your husband does qualify for what's called pre-trial release, which is a non-monetary release. He'll be released as it relates to this charge today. We can oppose, based on what you have to say, any conditions that you feel are appropriate and that the court feels are appropriate. So are you currently scared of him at all?
No.
All right. Do you wish to have contact with him?
Yeah, we married, so we have to be in contact with stuff.
Well, not necessarily. If you want to have contact with, I can order that you two have no contact. But if you want to have contact with him, the court has no problem with that as well.
Yeah, contact.
All right, you wish to have contact with him? All right. You two currently live together?
I have my own place, but I mostly be at his place.
All right. Do you want the court to order that you maintain separate residences?
We can.
What would you like the court to order? Separate residences?
Yeah.
Okay. All right. All right, sir. I'm going to appoint the Office of the Public Defender to represent you. I've reviewed the charging affidavit, and for the purposes of today's hearing, I have to assume everything in the charging affidavit is true. I'm not determining it's true or not, but that's the purposes of today's hearing, is just determine whether there's probable cause. The court's reviewed it, and it does determine there's probable cause. You're going to be released as it relates to this charge today under what's called pretrial release. I'm going to impose the following conditions. That you have no hostile contact with your wife, no hostile contact just means no fighting. I know that tough times like this, it's easy to get emotional. It's gonna be a condition of your release that you have no hostile contact. That means arguing, raising your voice or anything like that. It's just gonna be a condition of your release, sir, and that's, I understand. And if, I'm not gonna order that you have no contact, if that's something you're worried about, if you're worried about getting the police called on you, then it may be a good idea, you can make the decision to not have contact if that's what you wanna do. But I'm not gonna put it in a court order that you don't have contact. The only thing that's gonna go in a court order is that you have no hostile contact. So if you two are with each other and you are, it can't get hostile in any way, all right? Let's, yeah. I understand, when you see people out here at the jail, it's usually not their best day. I understand that. So we do this day in, day out. It sometimes feels like we're just going through the motions. I don't want it to feel like that, but that's what we do. Our job is to determine appropriate conditions of release. So I appreciate you bearing with us. I know that these, especially in these domestic situations, that emotions can run high. But the purpose of today's hearing is just to get you out of here appropriately, okay? So I'm going to order no hostile contact. I'm also going to order that you possess no weapons or ammunition. If you have any weapons or ammunition, I ask that you surrender those to law enforcement within 24 hours. I'm also going to order that you maintain separate residences. It's indicated to the court today that you have separate residences. You can have contact with each other. You don't have to have contact, but you can. And it may be a good idea, at least in the meantime, that you two stay at your own place. The court's going to order that you do that, that you maintain separate residences, okay? All right, other than that, you'll be released as it relates to this charge today under those conditions, okay? Anything further, ma'am? Anything further from you, ma'am, while they're speaking?
Oh,
Okay.
Judge, there's one issue. He doesn't want to have contact with her. He just asked if the court could indicate to her that she give him his insurance card. He needs it.
All right.
For work.
Yeah, no, I understand. Here's the thing. Right or wrong, you're the one that's charged with a criminal offense. So the conditions of release are conditions to you. I'm not ordering that you have no contact, because if you do have contact, she doesn't go to jail, you go to jail. You understand what I'm saying? If you don't want to have contact with her, you don't have to. I'm not ordering that you two have contact. I'm just ordering that if you do have contact, be no hostile contact. If you don't want to have contact with her, you don't have to. She has your insurance card.
Yes.
I can't order her to give it to you.
I paid for it. It's in my name too.
I understand. Well, what we're doing here today, I can't enter an order that says, I don't have those facts before me. I understand what you're saying. I just don't have that stuff before me. I'm not going to enter an order to that effect. Ma'am, I will just say to you.
I put it to his front door so he can have it.
I'll just say to you, I'll say to everyone, like I said, these things get emotional, and I understand that acutely, okay? I can't put it in a court order because it doesn't really mean anything. I'm just saying it from human being to human being, and from human being to human being. Try to be reasonable, okay? Both of you. And not putting any blame on one party or another. Just try to be reasonable. He says he needs an insurance card. If you can give that to him, that'd be great, sir. If you don't want to have contact with her, I'm not ordering you to have contact with her. You don't have to have contact with her. That's up to you. But she's indicated she's going to give you the insurance card. I hope she does. If not, you have an attorney appointed to represent you, and appropriate motions and all that can be filed and get it before the court with the appropriate jurisdiction to do that, okay?
Sir.
All right, good luck to you, sir. Thank you. Yep. Good luck, man. Thank you. Oh, I got you. Name, what's your name?
Marlene LeBron.
I don't know if I had a face sheet for her. Does she qualify for PTR?
Yes.
Is that the one I just threw away? Sorry. All right, Ms. LeBron. You're here on one count of battery domestic violence. I'll appoint the Office of the Public Defender to represent you. I've reviewed the arrest affidavit. I do find there's probable cause. You do qualify for what's called pretrial release. That's a non-monetary release. You'll be released as it relates to this charge today, okay? Because there's no victim here, I have to order that you have no contact with the alleged victim. I've appointed an attorney to represent you. I'm going to ask you to tell her, do you and the alleged victim currently live together? Okay,
Yes, they do, Your Honor.
all right. Because there's victims not here, I have to order that you do not return to the residence where but I will allow you to return to the residence one time with the accompaniment of law enforcement to get any personal belongings, okay? The way that works is that you call the cops first, coordinate a time to go over there. Don't show up there and then call the cops because that'll create problems, specifically for you. That you do not possess any weapons or ammunition. I've already ordered the no return with the exception for the one-time return for, to get personal belongings until further order of the court. These orders can always be modified if circumstances permit and are appropriate. I've appointed the Office of the Public Defender to represent you. Those, your attorneys can file the appropriate motions, but you're going to be released as it relates to this charge today with those conditions, okay? You have an attorney, you have the right to remain silent. Just be real careful about what you say. If you want to say, you might want to run it by your attorney first. Yep. All right, good luck to you, ma'am. Thank you. All right, sir, what is your name?
Ethan Altman.
All right, Mr. Altman, you do not qualify for the services of the public defender because you make too much money, so I'm not going to appoint them to represent you, okay? You do have the right to an attorney. If you want to hire one, you can do that. You do qualify for what's called pretrial release, which is a non-monetary release. So you are going to be released as it relates to this charge today. We're just going to determine the appropriate conditions, okay? Ma'am, what is your name?
Zaira Camacho.
State, did you have something?
Judge, I have that he does not qualify for PTR. I don't know if you have an updated one.
Oh, there was someone in between. What happened to Luis Machado Garcia? Did we already?
He handled him
We did.
earlier.
Thank you. All right, so you don't qualify for pretrial release. I'm still going to set a bond. So you'll have a bond in order to, if you want to bond out, and there's going to be some conditions of your bond, which we're going to determine what the appropriate conditions of the bond's going to be. Ma'am, what is your name?
Zaira Camacho.
Into the microphone, please.
Zaira Camacho.
All right. All right, Ms. Camacho, are you the alleged victim in this case?
Allegedly.
All right. Well, that's what, all we're here for is, what's been alleged. So you're the alleged victim in this case, correct?
Yeah.
Yeah, it's okay. Here's what happens. We get an arrest affidavit, and that's what the cops fill out. For today's purposes, I have to take everything that's written in that affidavit as true, whether it's true or not. For today's purposes and today's purposes only, we have to assume it's true. That's the way it works. And I've read it. I've determined there's probable cause. You are entitled to a bond. You're going to get a bond. So we're just going to determine if he bonds out, what the conditions of his release is going to be. Are you currently scared of him at all?
No.
You got to answer out loud.
No.
Okay. Everything's being recorded. So I see you shake your head, but yeah, that's why I don't care if you shake your head, but the court reporters, if I don't tell you to answer out loud, they call the clerk over here and tell them to yell at me, and make you answer out loud. So I'm trying to get ahead of that. Okay. All right. So were you previously sworn, by the way?
I was.
Okay. All right. So you're not currently scared of him?
No.
You two currently live together?
We do.
All right. How long have you lived together?
A year.
All right. Do you want him to come home?
I do.
All right. You want to have contact with him?
Yes.
Stay, do you have any other questions for this witness?
Ms. Camacho, were you and Mr. Altman at a restaurant?
No. Well, we were outside of a restaurant waiting. Yeah.
Okay, so you were outside
We were
a
not at a
restaurant.
restaurant. We were in front of a restaurant.
Understood. And did Mr. Altman have anything to drink alcohol, anything like that?
We both did.
Okay, did he?
Yes.
And did he seem to be intoxicated to you?
No.
Hey, the court will note that, I mean, alcohol was somewhat involved.
Yes, Judge.
According to the allegations, but just going on the paper, we're not getting into the truth of what actually happened today. It's not a trial. There's no jury here. We're just going on what's on the paper. If you have any other questions for you, you're free to ask them, but the court's gonna note that, it appears that alcohol was somewhere in the arrest affidavit, okay?
Yes, Judge, the state does not have any further questions.
All right. All right, so I'm gonna set bond at $500. I'm gonna order as a condition of your bond that you have no hostile contact. Hostile contact is just arguing. It doesn't have to get physical for it to be considered hostile contact. Hostile contact's like raising your voice, getting into an argument. If that happens and either you call the police or someone sees it and they call the police, if you're arguing in a parking lot in the future and the police get called, even if you don't touch her, it's gonna be a violation of your conditions of your release, and you can be picked up and brought back and held no bond, okay? So that's what no hostile contact means. I'm just saying it so everyone's on the same page, all right? I'm also gonna require that you possess no weapons or ammunition. And also gonna require that you consume no alcohol while on pretrial release, okay? Other than that, you have a bond, you can bond out with those conditions. Anything further from you, ma'am?
As far as the battery charge, he didn't put his hands on me.
I know.
Okay.
Like I said, today's not your trial. Whether the state files charges on this is to be determined.
Okay.
He just got arrested and picked up, and it's alleged that he did. So we're setting a bond, okay?
Okay.
All right, thank you.
Thank you.
All right, good luck to you, sir. Yep. All right, ma'am, what's your name?
Perez.
All right, Ms. Perez. You're here on one count of battery, domestic violence. I'll appoint the Office of the Public Defender to represent you. I've reviewed the charging affidavit. I do find that there is probable cause.
He hit me first, though.
Listen.
I was defending myself.
Listen, today's not the time it's not the trial. Like, we're not talking about the facts of what happened. It's not saying I don't believe you. I'm just saying, I find probable cause as to what's written on the four corners of what's in front of me. I'm gonna set bond in your case at $250, okay? I'm gonna order that you have no contact with the alleged victim. And like I said, alleged victim, if you're telling me, the court, that he hit you first, probably a good idea you don't have contact with him, okay? So no contact with the alleged victim. Now, it's not only just a good idea, it's an order of the court. And it's an order of the court that applies to you. It doesn't apply to him, okay? So if you if you show up at the house or something like that, and he calls the police, there's a chance you could be picked up and brought back here and held no bond. I'm also gonna order that you do not return to the residence where this was alleged to have occurred. If you need to return to get personal belongings, you can return one time under the accompaniment of law enforcement.
Okay.
The way that works is that you call the sheriff's office or whoever, whatever law enforcement agency first, and then you coordinate a time and a place to do all that. Don't show up to the house and then call the cops, because then there's a chance you'll be held in violation of your conditions of release, and that won't be good for you, okay? I'm also gonna order you possess no weapons or ammunition. And I believe that handles it. Anything else, State?
Nothing from the state, Judge.
All right, good luck to you, ma'am. All right, ma'am, what's your name?
Amelia.
Amelia Vasquez? All right, ma'am, what is your name?
Tanya Gutierrez.
All right, I'm gonna appoint the Office of the Public Defender to represent you. State and PD, this arrest affidavit was kind of all over the place. Like, there's Fabian. Fabian was charged with domestic battery. It seems like Tanya and Amelia's names got flip-flopped a few times. I'm just addressing these questions to the attorney. The way the arrest affidavit was filled out, it was a little confusing. I'm not certain, and I'll hear from the state, because it was so confusing, I haven't made a determination whether there was probable cause. If the state wants to direct me as to, like, the magic bullet or something like that, I'm happy to hear it, but reading all these this morning, this one made my eyes go cross and I gave up.
Judge, the magic bullet we're looking for, I think, is about 7 lines down. It says Tanya was upset that the cat was going to the bathroom and making the house smell. She asked Amelia to clean up the litter box or get rid of the cat. Tanya and Amelia continued to argue, and then Amelia grabbed both of Tanya's wrists.
Okay. All right. So battery is defined in Florida by any offensive, unwanted touching. So the grabbing of the wrist, as simple as it may sound to people who aren't involved in this day in, day out, is technically a battery. So the court will, based on that representation, find that there's probable cause. She does qualify for what's called pretrial release, which is a non-monetary release. She'll be released as it relates to this charge today. Were you previously sworn, ma'am?
Yes, sir.
Oh, okay. That thing will sneak up on you. You gotta look out.
I know, sorry.
Yeah, especially with the mask off, we can't, anyway. All right, what's your relationship to
My daughter.
to Ms. Vasquez? Okay. Do you wish to still have contact with her?
Yes.
All right. Do you currently live together?
Yes.
All right. You wish for her to come home?
Yes.
All right. State, do you have any questions for this witness?
Has anything like this happened in the past?
No.
No questions, Judge.
All right, so I'm going to order as a condition of your release that you have no hostile contact with your mom, okay? That means no arguing. And as I'm putting these conditions on here, they apply to you, they don't apply to your mom, okay? That's just the way it works, fair or not fair. I'm going to order that you have no hostile contact with your mom, no arguing. If things start looking like they're going to turn to an argument, it's incumbent on you to remove yourself from the situation because I'm ordering that you have no hostile contact with her, okay? You can return to the residence, obviously. I'm also going to order that you possess no weapons or ammunition as a condition of your release. Other than that, if I haven't done so already, I'll appoint the Office of the Public Defender to represent you. You'll be released as it relates to this charge today. Is there anything further from you, ma'am?
No, sir.
All right, good luck to you both. All right.
Thank you.
Mm-hmm. All right, sir, what is your name?
Robert Ward.
All right, ma'am, what is your name?
Sharon Ward.
All right, what's your relationship to Mr. Ward?
He's my husband.
All right. All right, Mr. Ward, you do not qualify for the services of the public defender. You make too much money, so I can't appoint them to represent you, okay? You do have the right to an attorney. You have the right to remain silent. Everything you say can and will be used against you. I'm just telling you that for your well-being. Everything in here is being recorded. The only purposes for today's hearing is to set a bond and appropriate conditions of release, okay? So we're not going to get into the facts of what happened, especially from you. She can talk about it if she wants because she's not charged with a criminal offense right now. But especially as it relates to you, I would advise you strongly to exercise that right. Just as a former criminal defense attorney myself, this is not the time to talk about all that, okay? All right. I've reviewed the arrest affidavit. I do find that there is sufficient probable cause. He is entitled to a bond. So we're gonna set a bond today.
I think he has
As a condition of your bond, we can impose certain conditions. Were you previously sworn, ma'am?
Yes.
Okay. We can impose certain conditions. Those conditions can include things like no contact, maintain separate residences. My review of the affidavit indicates there may have been some alcohol involved. The court's going to order that there be no alcohol while you're out on pretrial release.
Please.
But are you currently scared of him at all?
Yes.
You are? Do you wish to have contact with him?
No contact.
Okay. All right. Do you currently live together?
Yes.
All right. So here's what we're going to do. As a condition of your bond, based on the testimony that she's presented here today, I'm going to order that you have no contact with her, okay, while you're on pretrial release, until further order of the court. No contact means no contact. You have kids together?
Yes.
How many?
One and a stepchild.
One and a
of
step-
ours, and he's got one.
How old are the children?
The stepchild's 12, and ours is 1.5.
Okay.
I don't have any other residents here. She has her mother's house, so I didn't know if that was a possibility. If she stays, I don't have another residence. I'd have to stay.
Well, yeah, I understand. And these things are never clean. I mean, it's just the nature of how it works. You and the kids reside at hold on,
2516.
2516 Cassam Court?
Correct.
Okay. Do you wish to remain there, or do you have somewhere else you can
Yes.
go?
Yes, because I also have to take care of his stepdaughter during the week and everything, and we have an appointment on Wednesday after school, so I've already talked to her mother about it. I would like to be at the residence.
Okay. Well, until further order, the court, I mean, just based on the limited information I have here today, that court orders can be modified all the time. I would advise you to hire an attorney, obviously, and they can file the appropriate motions to get those modified. But in the meantime, I have to order what I'm about to order, okay? Just based on what was presented here today. I'm gonna order that you have no contact with her. No contact means no contact. That's Facebook, Instagram, TikTok, can't communicate through the children. That happens a lot, trust me. And it'll be a violation of the court order if you tell the 12-year-old to tell her something. If that's shown to be true, she can call the police, and the police can come pick you up, and there's a chance you're held no bond, okay? So no communication, no contact with her, period. Also, order that you consume no alcohol and that you possess no weapons. Also, that you don't return to the residence. I can allow you to go back one time with the accompaniment of law enforcement. The way that works is that you call the sheriff's office first, or Belle Isle Police, or whoever, whichever appropriate law enforcement agency that has jurisdiction. It could be the sheriff's office, Belle Isle Police, or any other agency that's willing to do it. But you have to call them first and coordinate it. You can't just show up there and then call the police, and because if you do that, that's the carts before the horse, and you'll be in violation of the condition, okay? So, and the purpose of that one-time return is to get any and all personal belongings that you may need. But then you can't stay there. You gotta stay on a couch, a hotel, something until the court modifies the no contact order, okay?
What about mail? I mean, all my mail goes there, so I have to keep on top of the bills. I'm the one that, she doesn't have authorization to pay the bills at the house, so they're all my checks.
No, I mean, I understand you're gonna have to figure it out. I know a lot of things now are done electronically. So you may have to contact Duke Energy, Wells Fargo, whatever
Want me to
bills are
help with
due.
that, or, I don't
What's
know.
that?
Should I help with that, or do I have?
I'm not gonna, we're not solving all your problems here today.
Yeah, okay.
And that's goes both ways. At some point, you gotta, not that you're not, but at some point, we're all grown-ups here. You gotta figure out how to get it done, all right? And I think you guys can figure it out. The only thing we're doing here today is that relates to the criminal charge.
Also, sir,
Yep.
Your Honor, he's locked me out of our personal safe. When he goes to the house, can I get my things out of the personal safe?
I'm not gonna address that right now, okay? I'll tell you what I tell everyone. I can't put it in a court order because it doesn't mean anything. Just be reasonable, okay? And that applies to both of you. I know these things get emotional and things happen, life happens. I'm not saying someone's right, someone's wrong, someone's telling the truth, someone's not telling the truth. I'm just saying with what the court's ordering here today, there's stuff in the safe, there's not stuff in the safe, there's bills that need to be paid, there's bills that don't need to be paid. Everyone's adults. The court's gonna order that you have no contact, that you can return one time to get your personal stuff. I'm not gonna touch the rest of the life stuff you guys have going on. You guys can figure it out. Just as long as it's within the confines of the no contact order, okay?
How long is this no contact order?
Until further order of the court. It's gonna be condition of your pretrial release. You're not gonna have to post a bond. You're gonna be released as it relates to this charge today, but those conditions are gonna remain in effect. If you need the court order modified, like I said, my first step, if I were you, and this isn't legal advice, I can't give you legal advice, this is just practical advice. As soon as you get out of here, I'd go find an attorney and give them all your paperwork. And if you need orders modified, they can do that for you, okay? But today, the orders are gonna be what they're gonna be, all right?
What about contact my 12-year-old? Just a quick question.
I'm not gonna order that you have no contact with your children. You can have contact with your children. Just be careful, trust me. Been doing this a while. It happens all the time, intentionally, unintentionally. Do not communicate with her through the children. And I'm not saying you will, I'm just saying people stand right where you're standing and say, oh, I swear I'll never do that. Then they're back here in 2 days because they told the 12-year-old, tell mom to get me something out of the safe. And it's as simple as that sounds. It's a violation of the court order. You get brought back here and you're not entitled to a bond at that point. You might get a bond, but you're not entitled to one, okay?
Can I stay with family in another state or while I'm waiting the next?
That's up to pretrial release. What state? Not Hawaii, I hope.
No, it's like, that's where my family is. I don't have.
Where is it? Where's your, Illinois?
I don't have any family here, so like I'd have to stay in a hotel, which is cost prohibitive. I don't know how long these things take.
How long have you lived here?
Lived here for 26 years.
You don't have any friends?
All lives in Chicago.
You don't have any friends where you could, I mean, I'm,
Really, I mean, I kind of lost a lot of my friends over the years, so like.
okay. All right, I'm not making a judgment call on that. I'm just, again, it's one of those things you're gonna have to figure out. Can he go to Illinois then? I mean, that's kind of far.
That's up to his pretrial release officer, Your Honor. I'm not too sure. I believe he can travel out of the state as long as he reports. Due to his case is domestic, he has to report in office.
Okay. All right. The court has no objection to you traveling to Illinois and staying in Illinois. You're gonna have to do a cost analysis because it's a domestic case, you have to report to your pretrial release officer in person. So if you wanna keep coming back from Illinois to Florida to report in person to your pretrial release officer, you may end up spending less money staying in a Motel 6 somewhere, all right? Yeah, go ahead.
Not to add in, but it may be beneficial for him to just have a bond without PTR, because then he won't have to check in with PTR.
That's an option too. I'm gonna explain that to you. So I can give you a bond in lieu of PTR. Pretrial release is it's kind of like probation. So you'd be supervised. You'd have to check in. In domestic cases, you have to check in person. I can just give you a bond where there is no pretrial release, no pretrial supervision. The conditions will remain the same, the no contact order, all that stuff. So if you violate the conditions of your bond, you can still be picked up and you won't be entitled to a bond. But there won't be the reporting requirements that are associated with pretrial release. The court has no objection to you traveling to Illinois and staying in Illinois with the condition that you appear for any and all future court dates. So would you like to be on pretrial release and have that supervision component? Or would you like for me to set up, I'd set bond to $250, and then there's no supervision, but the conditions remain.
And if I get that, do I have it mailed somewhere else then, like all the court documents, so I know what, if I can't get in contact with her, just mail situation?
I can assist with that, Your Honor.
Yeah.
He can go to the clerk's office and file a
Change of address.
notice of change of address.
All right. So the clerk's office has change of address forms wherever you want your court mail sent, you could just let the clerk's office know, okay? All right? Anything? All right, thank you, sir. Good luck.
Are you setting bond at $250, Your Honor?
It's a bond with those conditions. We're not doing PTR so he can live. All right, thanks. All right, ma'am, sir, what's your name?
Your Honor, William Anderson refused.
All right, I'll appoint the Office of the Public Defender.
Waive his appearance, Your Honor.
All right. Mr. Anderson was here on a failure to appear, was set at no bond, will stay the bond at none. All right, sir, what's your name?
Michael DeVito.
All right, Mr. DeVito, you're here of burglary of occupied dwelling, trespass on property after warning, resisting an officer without violence. I've reviewed the arrest affidavit.
Your Honor, I have a probable cause challenge as to the burglary.
Okay, go ahead.
So it indicates, it's kind of confusing in the arrest affidavit, that he had allegedly appeared at the front yard, and that's why they called the police. It was a trespassing, and then he ran from officers, so resisting without violence. But then it says that he just entered the backyard to the home, and that separates the home from that. I believe that's what they're arguing is a burglary of an occupied dwelling. I don't know the intent to commit a crime therein applies there. And the fact that it's a backyard versus the front yard, I think it's not an occupied dwelling. It might be a structure at most, but I don't believe it's an occupied dwelling.
Or state any argument as to that? For some reason, I thought this involved a window. I may be confusing. Hold on.
Judge, I believe it was that he was attempting to open the window, but I don't believe that he ever got inside. As to the burglary of a dwelling, the dwelling being occupied or not does not matter for the second-degree felony burglary of a dwelling, just whether or not it is in fact a dwelling. There is probable cause from the owner of the home that, that is a dwelling that he and his daughter have stayed in. And, the fenced in back of it would be enclosed curtilage. The crime therein would be the resisting officer without violence. He was running from police while he went in there.
And if I may be heard as to the opening the window, from what I see, it says Michael has returned to the home several times, but has always left prior. Danny stated Michael has attempted in the past to open the window,
Okay,
at which he heard the knocking.
all right. Based on the state's argument, I understand defense argument. I think there is sufficient probable cause as to the burglary of an occupied dwelling. The offense to be committed therein would be the resisting. As crazy as that may sound to some, I think that is sufficient probable cause. So I'm going to stay the bonds on count 1 at 5,000, count 2 at 100, count 3 at 100. You're also out on bond on 2022 MM 4612AO and 2022 CF 6508AO. Based on the allegations in this most recent affidavit and the nature of the offenses you were out on bond on, I'm going to revoke the bond in both of those cases and set bond at none. Okay? I've appointed the Office of a Public Defender to represent you on both of those cases, so any appropriate motions should be, you need to coordinate that with your attorney, okay? Good luck to you, sir. All right, sir, what's your name?
Dominique Gill.
All right, Mr. Gill, you're here with one count of possession of methamphetamine and one count of, I've honestly never seen this before, public possessing a box with a registered mark. I reviewed the statute and reviewed the arrest affidavit. There's no allegations that the box contained a registered mark. So the court would be inclined, I'll hear from the state if the state wants to be heard on that, but I'm inclined to find no PC as it relates to that.
The state does not wish to be heard on that.
Okay. All right, so you'll be ROR'd on that count. I've never heard of that charge before, but I did look it up, and apparently there needs to be a registered mark on whatever box this is. And there was no allegations to that. So, do find probable causes to the possession of methamphetamine. I'm gonna stay the bond on that at $1,000, or no, you do qualify for pretrial release. So you're gonna be released as it relates to this charge today. If I haven't done so already, I'll appoint the Office of the Public Defender to represent you. State requesting any special conditions?
No, Your Honor.
All right. All right, good luck to you, sir.
I really appreciate you, boss.
Yep.
Have a blessed one, y'all.
Yep, you too.
Any conditions, Your Honor?
No, just the typical, yeah.
So no condition.
Yeah, just, yeah. I thought about it, and then. All right, sir, what's your name?
Your Honor, Samantha.
Yeah.
Refuse.
All right, I'll appoint the Office of Public Defender to represent Ms. Kuzka. She was here, or you waive?
Yes.
All right, I've reviewed the arrest affidavit. I do find there is sufficient probable cause, the possession of cocaine. Stay the bond, 2,000 in that case. It's also a case of 2 counts, possession of fentanyl, possession of drug paraphernalia. Find there's probable cause. Let's to each count. We'll stay the bond on count 1 at 2,000. Count 2 will be set at 100. All right, sir, what's your name?
Hyundai Andrew Lane.
All right, Mr. Lang, you are here on 1 count of grand theft 3rd degree and 1 count of petty theft. I'll appoint the Office of the Public Defender to represent you. Court's reviewed the charging affidavit, does find there's probable cause. Court's going to stay the bond on count 1 at $2,500, set bond on count 2 at $250. Also order that you do not return to the Best Buy or the Petco where these actions were alleged to have occurred, okay? All right, good luck to you, sir.
Honor Lazarus Mobius Bonded.
Bonded? All right. So what's your name?
Om Patel.
All right. All right, Mr. Patel, you're here on a warrant for fraudulent use of personal identity information. The bond on that is $1,000. I'm going to stay the bond. There's also conditions that you do not return to the scene of the alleged incident. You have no contact with any of the alleged victims, okay? I'll appoint the Office of the Public, you do not qualify for the services of the public defender, so I'm not going to appoint them to represent you. But you have a right to an attorney. I'd advise you, it's usually a good idea to hire one, okay? Good luck to you, sir. All right, sir, what's your name?
Craig Raymer.
All right, Mr. Raymer. You're here on one count of possession of methamphetamine, one count of possession of drug paraphernalia, one count of operating a vehicle without a valid driver's license. Court's reviewed the arrest affidavit. Does find there is probable cause. You're going to stay the bond in count 1 of $2,000. Stay the bonds on count 2 and 3 at $200. If I haven't done so already, I'll appoint the Office of the Public Defender to represent you, okay?
I was asking, 'cause originally those were 100 each, and they doubled them because I was out of state. The ID was out of state, but I live in state, so
You got, yeah,
I didn't know if that was able to go back down to what it was originally at 120.
well, you got a $2,000 bond too, so I don't know if we really want to get into the weeds on the subsidiary bonds that are.
Okay, but yeah, I mean, I was just asking.
Yeah, no, we're gonna leave them at what they are for whatever reason. We're just gonna leave them what they are. So you have bonds, 2,000 on count 1, 200 on count 2, and 200 on count 3. All right? Good luck. All right, sir, what's your name?
Ross Devon, for the records.
All right, Mr. Ross, you're here one count of grand theft, 3rd degree of motor vehicle. You do not qualify for the services of the public defender, so I can't appoint them to represent you. Came in with a bond of $1,000. I'm going to stay the bond at $1,000, so you have a bond on it.
Could I ask a question?
All right, let me just tell you something before you ask. You can ask whatever you want, but I'm just going to go over your rights with you because I haven't appointed the public defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. The purpose of today's hearing is just to determine a bond amount and any conditions of release. You have a bond of $1,000. We're not getting into the truth of any of the allegations. I've reviewed the affidavit as it was drafted by officers and determined it to be sufficient to allege that a crime has been committed. Whether that's true or not, that's what trials are for and discovery and all that stuff. Usually, it's not a good idea to talk about the facts of your case at first appearance. As an example I give, I've represented a guy who was charged by robbery while wearing a mask. We came here on, he stood at that podium. I stood right next to him, told him not to say anything. The court said, you're here on robbery while wearing a mask. He said, I wasn't wearing a mask when I went in there, it was a sock. So, what do you want to say?
I was. That's about the case. I don't even want to get in the case. I'm just asking you as a judge. I would do work and I provide for my children, right? I don't even want to get in the depth of this case. I'm asking you as a judge so I can return back to work tomorrow at a certain time because I do not want to miss my job.
Well, you make too much money to qualify for the services of the public defender. You got a $1,000 bond. If you go through a bail bondsman, that's typically, I can't tell you what they're going to do. It's typically $100. So if you can come out with $100 by the end of the day today through the telephone or so.
But I got the $100 in my property.
Well, you got to call.
Nobody, that's what I'm saying. I really don't have my people, my It's a whole lot. That's what, Master. Can I get like a OR till I could pay him?
I'm not gonna ROR you today. You got a pretty low bond, to be quite honest. If you can figure it out, you can be out today. All right? Good luck to you.
Yes, sir.
Your Honor, can you skip over St. Pierre?
Yep. What happened? What were we
He's in
doing?
the back, but he's in the restroom at the moment.
Oh, so we're skipping him. Gotcha. All right, sir, what's your name?
Kelagos Sneed bonded. And Justo Ventura Gomez bonded also.
I had a piece.
I didn't have Gomez.
Okay.
Did we have him?
Ventura Gomez?
Yeah, Ventura Gomez. Gomez.
I got Jerome next, then Wilcox. I didn't have Ventura Gomez, but if you bonded, Solomon? I think, this is Mr. Solomon?
This is, Wilcox Maxwell.
All right, do we know what happened with Solomon?
Inmate number?
220-20886,
He bonded.
bonded. Oh, Ventura Gomez, there he is, bonded.
So that.
All right, sir, what, oh, I'm sorry.
You're going to get a public defender on this. I don't know for sure if you will agree. Okay. We're ready, Your Honor.
All right, sir, what's your name?
Aaron Wilcox Maxwell.
All right, Mr. Wilcox Maxwell. You are here on one count of fleeing and attempt to elude and a moving traffic violation of driving while license suspended. That came in on a warrant, so a probable cause determination has been previously made. I'll appoint the Office of the Public Defender's Office to represent you in that case. Stay the bonds on count 1 at 1,000. Stay the bond on count 2 at 500. You also have the issue, you're out on bond, possession of a firearm by a convicted felon. The PD's been previously appointed to represent you in that case. There's also a resisting charge in that case as well. Given the history and the multiple times of resisting and fleeing and eluding, I'm going to revoke the bond in that case and set it at none. You have an attorney on that case. He's a good attorney. You need to get in contact with him as soon as possible so he can file the appropriate motions. All right? Huh?
What are you doing with the case? Under the
Revoke.
paper?
Huh?
Under the paper?
That's this one, right?
He has 2 cases here.
Oh. You have 2 cases. Oh, okay. You have a second case, possession of concealed weapon, firearm by a convicted felon. Possession of ammunition by a convicted felon. Possession of, another count of possession of firearm by a convicted felon, and resisting officer without violence.
Your Honor, may I be heard as to probable cause?
Yes. I'll appoint the public defender to represent you on that case as well. She's indicated she has a probable cause argument. I'm gonna turn things over to her, okay?
Yes, Your Honor. So he was charged with 2 counts of possession of firearm by a convicted felon. It's only alleged that 1 gun was found in the vehicle. So I don't believe that he should be charged twice with the same crime.
All right, and I'll hear from the state. On my understanding, having looked at that again, one of them's possession of a concealed weapon, and then one of them's possession of a weapon. So there may be different elements. I mean.
Maybe. It's the same gun, Your Honor, so I don't know why they would charge it twice.
I'm gonna find probable cause. I will set a nominal bond on the possession of a firearm. So we're gonna stay the bond in count 1 at 5,000. Count 2 will set bond at 500. Count 3, based on the argument and the allegations in the arrest affidavit, will set bond at 100. Set bond at $100 on count 4. But the bond, the case you're out on bond on, that's based on the new allegations and the allegations of the case you're out on bond on. That bond's gonna be revoked and set at none until further order of the court. All right, you have an attorney on that case already. He's a good attorney. You need to get in contact with him, sooner rather than later. And then he can file the appropriate motions. But that's all, I don't want you to say anything that's gonna come back to bite.
It's about the arm and the bond is the same thing.
So ROR is a type of release that in lieu of bond. So you were released on your own recognizance. Part of being released on your own recognizance is that you're not gonna pick up any new law violations because they were, and I'm not asking you to comment on the facts or anything, but because the nature of the case that you were released on, ROR, and the new cases that you picked up, we're revoking the case bond on, that you're out ROR on. And it's gonna be, bond's gonna be set at none until further order of the court. You gotta get in contact with Mr. Clark, your attorney, and have him file the motion, and he'll be honest with you, all right? Good luck. Mm-hmm. Oh, that was him, right? Oh, no, that's the St. Pierre. Sorry. All right, sir, what's your name?
Freddie Wilson Jr.
I guess Mr. St. Pierre really had to go. Huh? All right, Mr. Wilson. You're here on one count of criminal mischief, one count of assault.
Your Honor, may I be heard as to probable cause to the assault charge?
Yeah, I'd had some questions about that too. So we will appoint the Office of the Public Defender to represent you. She's indicated there's some probable cause argument to be made as it relates to the charge of assault. Counsel, you can go ahead.
Yes, Your Honor. In the affidavit, it indicated that there was a threat made, but it was as he was running away. I would argue that it's not imminent harm. It says something about coming back, or to that indication of it's not immediate, it's not imminent. He's running away. I don't think that there's a valid threat for assault.
Stay, I see where the victim said she was in fear that he would come back. So is.
It agrees, Judge.
All right. So we'll find no probable cause as to the assault. So we're gonna ROR you as to the assault charge. Do find probable cause that relates to the criminal mischief. We'll stay the bond at $1,000. Question for the state, is the alleged victim in this case the same as the alleged victim as 2022 MM590AO?
Yes, Judge.
All right. Based on it being the same victim that you ordered to have no contact with the alleged victim in this case, or even if it was no hostile contact, I'm going to revoke the bond in that case and set bond at none until further order of the court. I know you don't want to hear it, but we got to do it. Okay? I've appointed, if we haven't already, I'm appointing the Office of the Public Defender to represent you on that case. You need to get in contact with your attorney to have any appropriate motions filed that relates to that no bond, okay? Good luck to you, sir.
This is St. Pierre.
All right, Mr. St. Pierre. You are here on 3 counts, 1 count of possession of methamphetamine, 1 count of resisting an officer without violence, 1 count of possession of cannabis, greater than 20 grams. This came in on a warrant. No probable cause determinations previously been made. Bonds in count 1 is 2,000, count 2, 500, count 3, 500. We're going to stay the bonds. I'll appoint the Office of the Public Defender to represent you. Okay? Good luck to you, sir. What's this? Oh, oof.
You can call somebody, they'll let you go do that, just not right now. You're gonna go back and then you can call somebody. You can get out if you can bond it.
Good luck, sir. All right, sir, what's your name?
Sean Baggett.
All right, Mr. Baggett, you're here on a warrant for failure to appear. The bond in that warrant was set at $500. Court's going to appoint the office of the public defender to represent you if they have not been previously appointed. And I'll stay the bond at $500. Okay? Yep. Good luck to you. Thank you. All right, sir, what's your name?
Kenai Bruton.
All right, Mr. Bruton. You're here on one count of driving while license suspended with knowledge. Court has reviewed the arrest affidavit, does find there's sufficient probable cause. I'll appoint the office of the public defender to represent you. I'll stay the bond, well, I'm gonna set bond at $250. What, who's this? What's your name? What's your name again, sir?
Kenai Bruton.
Yeah, I'll set bond at $250. It looks like you may have some warrant, some holds out of Osceola County, okay? I don't know about that. I'm just saying it looks like you may or may not. As it relates to the case that you're here in front of me on, the new driving while license suspended, you got bond at $250. All right? And I appointed the office of the public defender to represent you. All right, ma'am, what's your name?
Juliet Acosta.
All right, Ms. Acosta, you're here on one count of possession of drug paraphernalia. I'll appoint the office of the public defender to represent you. I've reviewed the arrest affidavit. I do find there is sufficient probable cause. Is there an offer to resolve this one?
Judge, there's no offer in this case because it's connected to a co-defendant case with a significant amount of drugs.
Yep, fair enough. All right. So there's no offer to resolve your case here today, so we're just gonna set bond. I'm inclined to stay the bond at $1,000. So you're gonna have a bond on this case. No other conditions of your bond. We've already appointed the office of the public defender to represent you, okay?
May it be heard, Judge, just quickly, she had an IA hold, so I don't believe she was interviewed for pretrial release. Would it be possible to order her to be interviewed, and if she qualifies, PTR as as an opportunity?
Give me 1 second. Yeah, we can order that if she qualifies for PTR, she be released PTR without a bond. Otherwise, if she doesn't qualify for PTR, the bond's gonna be stayed at 1,000.
Yes, Your Honor.
Okay? All right, sir, what's your name?
Bryant.
All right, Mr. Bryant. Here on one count of battery. I'm gonna appoint the office of the public defender to represent you. You do qualify for what's called pretrial release.
I don't understand what that is.
I'm gonna explain to you. Hold on 1 second. I'm gonna say any objection to ROR, given the allegations in this. I'll explain what that means in a second. Looks like they were here possibly on vacation. It's like pushed a friend. They were fighting over like pizza and video games.
Judge, I wouldn't object as long as there's a no contact
Yeah.
order to be included.
All right. So ROR means you're gonna be released and there's not gonna be, you don't have to post a bond.
Am I gonna be released today?
Yeah. But there's gonna be some conditions.
Yes, sir.
Because the victim's not here, I have to order that you have no contact with the victim, okay? No contact means no contact, means no Facebook, email, TikTok, Instagram, WhatsApp, Chatterbox, I don't know, whatever's out there. Can't have any contact. No communication with the victim through third parties. Okay? You also have to, I appointed the Office of the Public Defender to represent you. I'm gonna require you stay in contact with your attorney, okay? So, if your address changed, your contact information changed, you need to call the Office of the Public Defender's office and let them know that your information has changed. Because, it looks like you live in Ocala.
Yes, sir.
You're gonna have court dates in Orange County potentially. The state may not file charges on this. They may file charges. If they do file charges, then you're gonna have court dates in Orange County. Benefit of having an attorney is that sometimes you don't have to show up to court. But only your attorney can tell you that. If you have a court date and you don't show up to court, the warrant gets issued. A lot of times it's a no bond, and you get picked up in Ocala, get brought back to Orange County, and sit here for who knows how long till you can see a judge, this, that, and the other, okay? So it's very important. I'm gonna make it a condition of your release that you stay in contact with your attorney. Other than that, you're to have no contact with the alleged victim. I'm also gonna order that you possess no weapons or ammunition. If you have any of that, you need to surrender that to law enforcement. If you don't, you don't. But if you do have it, I'm just gonna ask that you surrender it to law enforcement within 24 hours of your release. Okay? Good luck to you, sir.
Thank you.
Your Honor, Claude Malloy's behavior.
All right. It's here one count of petty theft. I'll appoint the Office of the Public Defender to represent him.
Wait, this appearance.
All right, I've reviewed the arrest affidavit, will find probable cause, will stay the bond at 500. Also appoint the public defender to represent him in 2022 CF 9106 AO. I'm going to revoke that bond and set that bond at none.
Jacob Roberts bonded.
All right, I also have Gulkan Ozdas, 220-20909.
I think she also.
Bonded, Your Honor.
All right, bonded. Roberts bonded. All right, sir, what's your name?
Jamal Robinson.
All right, sir. I'm going to appoint the Office of the Public Defender to represent you. You're here on, hold on. You're here on one count of accessory after the fact. I've reviewed the arrest affidavit. I do determine there is probable cause. I'm going to appoint the Office of the Public Defender to represent you. You also have the Public Defender's Office representative, or appointed to represent you in 2022 MM 6063. Sir, this is very important what I'm about to say, so I want you to pay close attention. Anything you say can and will be used against you.
Yes, sir.
I don't want you putting yourself somewhere where you may have, listen, hold on. The less you say in this situation is probably better for you, and I'm saying that looking out for your best interest. I know that you may not seem like that, but I'm telling you, okay? I reviewed 2022 CF 9397 AO. Appears there was, the victim in that case was Aquanette Harrison, okay? She's a co-defendant in this case. There was a no contact order entered, and listen, I don't want you to say anything. The purpose of today's hearing is very limited. I'm going by the facts that are alleged. Because there was a no contact order in that case, and because that alleged victim is an alleged co-defendant in this case, court finds on view that you violated the no contact
Sir,
order.
she let me come back home.
Hold on. That's exactly.
All right, if you're gonna revoke my bond, just let me get up out of here. Hey,
Well, listen to me. And this is why I want you to listen real quick.
I don't wanna listen.
I know you don't, but it's important. It's important for me to get off my chest because now I feel bad.
I mean,
That's exactly why I didn't want you to say anything. Now you understand that you've admitted on the record.
I don't
that-
care.
Well,
I mean, she called the police the day I got out to bring me back to the house. That's the only place I had to stay, sir.
well,
The police said that I can go back there.
what you want? I mean,
I don't care. I mean, she ain't gonna come to court. I mean, I don't care about this. I mean,
well, you're going to be held no bond on this.
all
one
right, so
because-
what? All right, you gonna do that anyway? What else
Well,
you got to say?
I don't take pleasure in doing it. I know you don't believe that, but
That's bull. The dude who I went with, he wouldn't have come up here and man up to what he did. That's what I'm saying. Man willing to come man up to the other stuff. I never was seen in no store, sir. I never got out no truck. I never did nothing, sir. I mean, I'm real, I know I was around the victim, you know what I'm saying, but we called the police, and we did everything for me to get back home. That's the only place I ever had to stay.
Look, sir, the more you talk, the more stuff you're putting on the
One
record.
thing about me, I don't
For
give
the
a
state
damn
of
about
Florida
that,
to use to
man.
prosecute you, so.
You ain't trying to hear shit, you just want to just revoke my bond.
Yeah, I heard it all, believe me. So, good luck to you. You can lead a horse to water. All right, sir, what's your name? Oh, ma'am, sorry. Tony Snulligan? What's your first name?
Tony.
Okay, maybe a little backwards how I got it, but making sure we're talking about the same person. That was Jamal Robinson, right?
Yes, Your Honor.
All right. All right, ma'am, you're here on one count, providing false ID to law enforcement and resisting officer without violence. I'll appoint the Office of the Public Defender to represent you. I've reviewed the arrest affidavit. I do find there is probable cause. We'll set bond on, state bond on count 1 at 500. Set bond on count 2 at 100. I don't know how I knew he was going to talk. That's why I told him it was so important to listen. But you just got that feeling, and I knew he was going to say something. Oh, boy. All right, ma'am, you have bond, so you can bond out, and there's no other conditions other than posting your bond, okay? All right, good luck to you. All right, sir, what's your name?
Rendell Daniels.
All right, Mr. Daniels, you're here, you came in on a warrant, so a probable cause determination's been previously made. It's a VOP warrant, so you're not entitled to a bond, and the judge assigned the warrant, ordered you be held no bond. I'm gonna stay that, okay? Good luck to you, sir. All right, sir, what's your name?
Green.
Willie Green. You didn't used to play wide receiver for the Florida Gators, did you?
Yes, sir.
Did you?
Yes, sir.
All right, Mr. Green. You're here on a violation of probation warrant. The warrant was signed by a judge that indicated you'd be held no bond. I'm gonna stay that bond at none until further order of the court, okay? What's that?
Yes, 2 cases.
That was one case. You also came in, why is there no bond on that one? Hold on, I'm just trying to I'm trying to make sure I'm talking about the same thing too. All right. You're also here on new law violations of possession of a controlled substance, resisting officer without violence, and escape. Hold on one second. I'm going to appoint the Office of the Public Defender to represent you. I'm reviewing the arrest affidavit now just to determine whether there's probable cause to hold you on that. I'm just going to read it. I'm just reading it for myself. I'm asking sincerely because I'm not sure. What's the PC for the escape as opposed to the resisting? Are they the same?
Judge, so they had him in double-locked handcuffs. They searched him. They found the pill. After searching Willie, I moved to open the rear passenger door to my patrol vehicle. I maintained one hand on Willie's left bicep. The other deputy had a hand on Willie's right side. As I opened the door, Willie twisted his body and broke free from my grasp. Willie immediately ran eastbound on the 26th Street towards Orange Blossom Trail. The deputies gave chase. and lost sight of him around the 26th Street and Orange Blossom Trail.
All right, let me look at something real quick.
The difference between the resisting and the escape is that they had him in custody at that time.
All right, I've reviewed the statute, 944.40 says, any prisoner confined in or released on furlough from any prison, jail, private correctional facility, road camp, or other penal institution. It looks like there's a little more than just regular custody to constitute an escape. So I'm gonna ROR as it relates to the escape. Do found probable causes to resisting without violence and possession of controlled substance. Set bond on count 1 at $1,000. Hold on one second. Set bond on count 2 at $100. So you have bonds on the cases you came in on. Yeah. All right, sir. You have bonds on the cases, the possession and the resisting that you came in on. Unfortunately for you, there was a violation of probation warrant that was also issued that came in with no bond, and the court's gonna stay that until further order of the court, okay?
Can I say something, Your Honor?
I don't know if you were in here earlier. It's usually not a good idea, but
The pill that they found him.
I'm gonna stop you right there. Today is not the day. Yeah, and I don't want you to say something on the record that's gonna be used to prosecute you later on. So you got a bond on that case. The VOP is what you really need to be worried about, and I've appointed the Office of the Public Defender to represent you on that. Good luck to you. All right, sir, what's your name?
Your Honor, James Cook's in the hospital.
In the hospital? Okay. I'll appoint the Office of the Public Defender to represent Mr. Cook. I'm inclined to ROR him. It's an open container. State, do you have any objection?
No objection from the
All
state
right.
judge.
So he'll be ROR'd. All right, sir, what's your name?
Scott Danieluk.
All right, Mr. Danieluk, I've reviewed the arrest affidavit. I do find there is probable cause for disorderly conduct. It's a weird name for what the conduct is, but there is probable cause. I'll appoint the Office of the Public Defender to represent you. State, do you have an offer to resolve this case? It looks like we're approaching with a plea form, so I'm assuming that's been
Just asked not to be
communicated.
appointed in this
Yeah.
case, Your Honor,
All right,
as a friend of the court.
yes. I'm not going to appoint the Public Defender to represent you, but there is an attorney from the Public Defender's Office standing next to you as a friend of the court. Do you have an opportunity to go over this plea form with that attorney?
Yes.
All right. You understand that by resolving your case here today, that there's not going to be a trial?
Yes.
You understand that by resolving your case here today, you're waiving all the rights associated with going to trial?
Yes.
Are you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
No.
Has anyone threatened you or coerced you to enter this plea?
No.
You understand if you're not a U.S. citizen, a plea to this offense would subject you to deportation?
Yes.
And do you understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes.
And do you understand that if you are on probation for a separate offense, a plea to this offense might be used to violate that probation?
Yes.
All right, we'll accept the no contest plea, withhold adjudication, sentence you to 1 day in the Orange County Jail.
2 days.
2 days in the Orange County Jail with credit for 2 days' time served. You'll be released as it relates to this charge today. Court costs will reduce to a final judgment. And that's it for you today, sir, okay? Good luck to you. There you go. Nothing further. We'll be in recess until tomorrow.
All right, good morning, good morning. Hey, Deputy Kenny, how you doing?
Doing good, Judge. Now, how you doing?
Doing pretty good here. Apologize for the delay here. I was wrapping up a few things, but I'm ready here. Appreciate your patience.
Okay, well, we're ready to begin as well.
Okay, perfect. All right. And who's on the female side?
It should be Deputy Dunbar.
All right, looks like he's still off. Deputy Dunbar, can you hear me? All right, Deputy Kenny, we're gonna go ahead with the males here and see if you can maybe reach out to the other side.
Yes, Your Honor.
All right, I'll give it a moment here.
Your Honor,
Yes, sir.
we're here on the female side. My apologies.
All right, appreciate it. Thank you. Deputy Dunbar, how you doing this morning?
I'm good. How about yourself?
Doing pretty good here. All right. Ladies and gentlemen, good morning to you. This is the Magistrate Court of Clayton County. Today is August 30th, 2022. Judge Knight's presiding. We're here for first appearance, and what's happening this morning is that I will inform you of what you're charged with, what your bond will be, if there are any special conditions of bond, or I will appoint an attorney to represent you if you qualify. But before I do any of that, I must inform you of your United States constitutional rights. These rights never go away, can take from you, and you are the only person who can voluntarily waive those rights. This morning is you have the right for the state to prove this charge or these charges against you beyond a reasonable doubt. The state is the district attorney if you're charged with a felony. The state is the solicitor general if you're charged with a misdemeanor. Also, the state includes any witnesses that may be called to testify against you. Those are known as state actors. So for example, the arresting officer, the drug technician, anyone involved with testifying against you and prosecuting you will be considered the state. Also, you have the right to a speedy and public trial by jury. You have the right to see, hear, and cross-examine any witnesses that the state may call to testify against you. You have the right to subpoena witnesses on your own behalf and to testify on your own behalf if you choose to do so and to present evidence. If you choose not to testify, no presumption of your guilt may be raised. Also, I must let you know I don't work with anyone. I don't work with the state, the sheriff, the bonding company, the district attorney, the solicitor general, the public defender, Lister Holt and Dennis. You would have to speak to someone from those respective agencies if you would like questions answered about those agencies. The answer from me is I don't know, because I don't know what the policies are from day to day and what they may tell you. So I'm not going to speak for any of those agencies. Some of you will not get a bond today. By law, I can't give you a bond. You must get a bond from a Superior Court judge. Also, some of you will get a special condition of bond. That means you can't go somewhere or you can't contact someone. So for example, if I say don't go to 123 Main Street, can't go there. Don't contact Joe Smith, can't contact that person. Also, failure to comply with the special conditions will result in the revocation of your bond or additional new criminal offenses. So take those special conditions seriously. Also, the bonding company will let you know what the fee is and the percentage and all of that. They know. I do not. I can just tell you the total amount for your bond. Also, I will appoint an attorney to represent you. Your attorney is the person you need to speak to about if you don't get a bond, what's going to happen next. This is what happened. This is what I think you should know. Today is not a trial. It's not a hearing. It's not for you to plead your case, so to speak, because no one's here from the state. It's just you and me. So if you tell me something, there may be nothing that I can do except listen to you, but I must let you know this is being live streamed on YouTube today. Someone could be looking at it now, or they could look at it at a later date in the archives. So govern yourself accordingly with what you may choose to say. That will be on you. Also, I will appoint an attorney to represent you if you qualify based on the application for court-appointed counsel that you completed today. Each of you raise your right hand, please. Each of you solemnly swear or affirm any statements or testimony you will give in this matter not pending before the court shall be the truth, the whole truth, nothing but the truth, so help you God. All right. So one more thing. Your preliminary hearing is your next court date. That is a probable cause hearing. Probable cause means it's the burden or standard that the state has to show before your case can proceed to state court if you're charged with a misdemeanor, superior court if you're charged with a felony. The arresting officer, detective, witnesses, whoever, they will come and testify, and they will say, this is what happened, this is what the person did. And if it's shown that there is sufficient probable cause or a valid reason why your matter should move forward, then your case will be bound over to state court if you're charged with a misdemeanor, superior court if you're charged with a felony. You can waive your probable cause preliminary hearing at any time. If you bond out of jail, as you should, if you're entitled to, with no holds on you, then your preliminary hearing automatically goes away. If you're charged with a felony, September 12th, misdemeanor, September 13th. Bond out of jail, you'll wait in the mail and stay in touch with your lawyer for a new court date or a notice in the mail from the clerk. All right, gentlemen, be on standby. We'll have the ladies first.
Your Honor, did you want to start with the, I don't know if you had the interpreter ready.
It's no interpreter here, so let's keep it going. Who's the person for the interpreter?
It's gonna be Diaz, Picado Diaz.
Diaz?
Correct.
All right, she's gonna have to come back tomorrow.
All right. That's something.
We have two that needs an interpreter over here as well, Judge. So you want to wait until tomorrow?
Yes, sir. Let's do the females. We'll get to you shortly. Yes, ma'am. What's your name?
Letitia Berry.
All right, Miss Barry. One moment here. All right, charge of one count of no or invalid license, 1,000. Falling too close, 1,500. Preliminary hearing, September 13th, 8:30. And I am appointing an attorney to represent you. Ms. Berry, you have any questions?
No.
All right, thank you. Yes, ma'am. What's your name?
Jasmine Matthews.
All right, Ms. Matthews, you're charged with 1 count of battery, a simple battery. Your bond is 5,000. There's no contact with Michael Harrison at this time. Preliminary hearing is the 13th of September, 8:30. And I will appoint an attorney to represent you. Do you have any questions?
No.
All right, thank you. Yes, ma'am. What's your name?
Good morning, Tanisha Miller.
All right, good morning to you, Ms. Miller. You're charged with 1 count of simple battery, 2,500. Disorderly conduct, 1,500. No contact with Cynthia Stolly is your special, or Sally is your new special condition. September 13th, 8:30. Preliminary hearing. Also, you're hiring your own attorney. You have any questions?
No, sir.
All right, thank you. Yes, ma'am. Good morning. What's your name?
Good morning, Tracy Miller.
All right, Ms. Miller, you're charged with 1 count of simple battery. Your bond is 2,500. No contact with Cynthia Stolly. September 13th, 8:30, preliminary hearing. I am appointing an attorney to represent you. Do you have any questions?
No, sir.
All right, thank you.
Thank you.
Yes, ma'am. Good morning. What's your name?
Good morning, Sakara Randall.
All right, Ms. Randall, 1 count of battery, 5,000 is your bond. No contact with Terry Stuckey, 681 Flint River Road, apartment 44E, Jonesboro Road. You can't return there at this time. You must make contact with the sheriff or the police or the Riverdale Police, and they will escort you to that location. That's the only time you can return. You must do so within 10 days of your release. Do you have any questions?
I do. I was wondering if I could be released because I'm breastfeeding my son and he only drinks breast milk, and as well as my daughters. They're at homeschool. I homeschool them.
Where are they now?
They're with my mom, and my son is as well.
All right.
And he's a newborn. He breastfeeds.
I understand that, ma'am. You have to talk to your lawyer, okay? See what your lawyer can do about getting you out. I can't reduce your bond at this time.
Okay.
Yes, ma'am. Thank you.
Good morning,
Good morning to you. What's your name?
Yolanda Watts.
All right, Ms. Watts. 1 count. Battery, 5,000 is your bond. 1 count. Cruelty to children, 3rd degree. 2,500. No contact at this time with Brianna Neighbors. Preliminary hearing. September 13th, 8:30. And I am appointing an attorney to represent you. Do you have any questions, Ms. Watts?
No, sir.
All right, thank you.
Thank you.
Yes, ma'am. Good morning. What's your name?
Good morning, I'm Haley West.
Said your last name is West.
Yes, sir.
All right. All right, Ms. West. You are charged with one count of abandonment. 1,500 is your bond.
Yes,
September 13th, 8:30 is your preliminary hearing.
Mr. President. Thank you.
Yes, ma'am, thank you. Good morning to you.
Good morning, Your Honor.
All right, what's your name?
Bianca ZZ Payton.
What's your last name?
ZZ Payton.
Okay, Ms. CZ Payton. You're charged with one count of criminal trespass. Your bond is 2,500. One count of simple batteries, 2,500. No contact with Veronica Payton at this time. Your preliminary hearing is scheduled for the 13th of September. That is at 8:30. And I am appointing an attorney to represent you. You have any questions?
No, thank you.
Yes, ma'am. Thank you.
Thank you.
All right.
Your Honor, that excludes all females from there.
Yes, sir. All right.
Users.
Thank you. See you next time. All right. Yes, sir. What's your name? Good morning.
Hey, good morning. How you doing? My name is Jaquavius Banks.
All right. One moment here, Mr. Banks. I'm doing pretty good here. You're charged with one count of burglary. It's a felony. There's no bond this morning on that offense. Preliminary hearing is scheduled for September 12th, 8:30. And your bond hearing one moment here. All right. Your bond hearing is scheduled for September 16th, 8:30. You have any questions, sir?
Yes, sir.
All right.
When my case was set up, they told me that it was a burglary, but it wasn't a burglary though, because we had the key to the house and we were staying there. You feel me?
All right. That's for you and your lawyer to talk about, sir.
All right, so no more.
All right. Thank you.
Have a good day.
You too.
All right, Cruz.
Yes, sir, Mr. Cruz. You're charged with burglary. It's a felony. There's no bond on that offense today. Preliminary hearing is scheduled for the 12th of September, 8:30. And your bond hearing is scheduled for the 16th, September, 8:30. And I am appointing an attorney to represent you. You have any questions, sir?
No.
All right.
L.
Who is it?
L.
All right.
Sir.
All right, Mr. Els, you're charged with one count of criminal trespass. Your bond is 2,000. Preliminary hearing scheduled for the 13th of September, 8:30. And well, looks like you refused counsel. Do you have any questions, sir? You have any questions?
If there's any way that I can change counsel if I'm not able to come up with the law at the time, or is that
Yes,
fine?
yes, you can do so.
Okay, that's awesome.
All right.
All right, thank you.
All right, let's see. You're welcome. All right, let's see when Ms. Toles is here. Ms. Toles, good morning to you.
Good morning, Your Honor.
Hey, how you doing this morning?
Happy Tuesday.
Happy Tuesday it is. All right, let's see. The individuals that need the Spanish interpreter, if they can appear together at this time.
Garcia, Rico. Rico. Garcia, bring it in.
Is there another person?
He's coming, Judge.
All right. All right. Yes. All right, Ms. Toles, you're on the oath here. Translate accurately from Spanish to English, English to Spanish to the best of your abilities. So help you God.
Yes, sir.
All right, if you can, ask the gentleman here to raise their hand and state their names.
Señores, buenos días. Por favor, levanten la mano y digan sus nombres.
Mi nombre es Gustavo Olvera Rico.
I am Gustavo Olvera Rico.
All right.
¿Y usted, señor?
José Alberto García Posadas.
I'm José Alberto
García.
García Rosales.
García Posadas.
García Posados.
All right. So, gentlemen, you are here in Clayton County Magistrate Court for first appearance.
Bueno, señores, ustedes están aquí en la sala menor del Tribunal de Primera Instancia del Condado de Clayton para su comparecencia inicial.
I'm Judge Knights, and I'm going to inform you what you're charged with and your bond amount.
Yo soy el juez Knights y les voy a informar de qué se le acusa y también de cuánto es la fianza.
All right, and Mr. Garcia will appoint an attorney to represent.
Y señor García, le voy a designar un abogado de oficio para representarlo.
All right, you have certain constitutional rights that never go away.
Bueno, señores, ustedes tienen ciertos derechos constitucionales que nunca se desaparecen.
You have the right for the state to prove these charges against you beyond a reasonable doubt.
Tienen derecho a que el Estado prueba esas acusaciones en su contra fuera de toda duda razonable.
You have the right to a speedy and public trial by jury.
Tienen derecho a un juicio público y sin demora ante un jurado.
You have the right to see, hear, and cross-examine any witnesses that the state may call to testify against you.
Tienen el derecho a ver, a escuchar y a contrainterrogar todo testigo que presente el Estado para declarar en su contra.
Also, each of you have a bond. You're charged with misdemeanors.
También los dos tienen fianza, se le acusa de infracciones menores.
If you bond out of jail, your preliminary hearing, which is your next court date, automatically goes away.
Si sale en libertad bajo fianza, la audiencia preliminar, que sería su próxima cita judicial, se desaparece.
And then you will be on standby, and you will then get notice in the mail for your next court date, which is your arraignment.
Luego ustedes estarán en espera de su próxima cita judicial, la notificación de la fecha de la próxima cita judicial, que sería la instrucción de cargos.
At each proceeding, you get the right to see, hear, and cross-examine the witnesses that the state may call.
En cada diligencia judicial tienen el derecho de ver, a escuchar, contrainterrogar los testigos que el Estado va a llamar en su contra.
All right. Each of you raise your right hand.
Bueno, si pueden levantar la mano derecha.
Do you solemnly swear or affirm any statements or testimony pending before the court shall be the truth, the whole truth, nothing but the truth, so help you God?
Juran solemnemente que las declaraciones o afirmaciones que van a presentar ante ese tribunal será la verdad y toda la verdad.
Sí, jurado.
Yes, swear.
All right, you can place your hands down, gentlemen.
Muy bien. Gracias, señores. Pueden bajar la mano.
All right, for you, Mr. Rico, you're charged with one count of driving without a valid license. Your bond is $1,000.
Muy bien, señor Rico, se le acusa de una sola infracción de manejar sin licencia. La fianza para esa infracción es $1,000.
For you, Mr. Garcia, you're charged with driving under the influence of alcohol less safe. Your bond is $5,000.
Y para usted, señor García, se le acusa de manejar bajo los efectos de alcohol, ser un conductor arriesgado, y la fianza es, if your honor, just to make sure, the bond amount was $5,000.
Yes, ma'am.
Y la fianza para usted es $5,000.
All right, and your preliminary hearing is scheduled for September 19th at 8:30.
Y la audiencia preliminar se señala para el 19 de septiembre a las 8:30 de la mañana.
All right. Do you have any questions?
¿Tienen alguna pregunta?
Todo bien.
No, that's fine.
Fianza 5,000. Perdón.
And my bond is $5,000?
Yes, sir.
Sí, señor.
All right, any other questions?
Muy bien. ¿Alguna pregunta más?
No, todo bien.
¿En qué tiempo
No,
la puedo,
that's
en qué
good.
tiempo, en qué tiempo la puedo pagar?
And how much time may I pay my bond?
That will be up to you, sir.
Eso depende de usted, señor. Okay.
All right, that will conclude your first appearance.
Muy bien, señores. Su comparecencia inicial queda concluida.
All right, thank you, Ms. Toles, and
Thank you, Your
we'll
Honor.
see you next time. Thank you.
All right, take care.
You too. All right. All right, what's your name, sir?
Brendan Hogan.
All right, Mr. Hogan, you're charged with several offenses here. Go ahead and listen keenly for me. The first is reckless driving. Your bond is 2,000, improper passing, 500, improper lane change, 500. Obstructing or hindering a law enforcement officer, 1,000. Too fast for conditions, 500. Wrong side of the road, 500. Striking a fixed object, 1,500. Hit and run, 1,500. Failure to maintain or an authorized vehicle, registration, 2,000. Unlicensed resident, 1,000. Improper turn signal, 500. Violation of the seat belt law, 500. So let me get your total here. One moment. All right, 16,000 is your total, sir. Also, your preliminary hearing is the 13th of September. That is at 8:30, Mr. Hogan. And lastly, here, one moment. All right, I will appoint an attorney to represent you. You have any questions, sir?
No, sir.
All right, perfect. Thank you. Yes, sir. Good morning.
Hannah?
All right. You said, what's your name again, please?
Good morning, Your Honor. My name is Michael Hanna.
Oh, yes, sir, Mr. Hanna. Good morning to you. So you're charged with one count of criminal damage to property, second degree, 2,500. Cruelty to children, 2 counts, is 2,000 each. Family or violation of the family violence ordinance, 5,000. No contact with Simone Hannah, 306 Villa Rica Drive. You can't return to that location at this time. All right, your preliminary hearing is the 12th of September, 8:30, and I'm appointing an attorney to represent you. You have any questions, sir?
What is that total, please?
$11,000.
Thank you.
Yes, sir.
Nathan Hamel.
Yes, sir. What's your name?
Nathan Hamel.
Okay, Mr. Hannah, good morning to you, sir. You're charged with one count of cruelty to children in the 3rd degree, 2,000. Terroristic threats, 2,000. Obstruction or hindering a law enforcement officer, 1,000. No contact with Simone Hammond. September 12th, 8:30 is your preliminary hearing, and I am appointing an attorney to represent you, sir. You have any questions?
Yes, sir. How much is that total? Like 5,000?
Yes, sir, 5,000.
5,000. Yes, sir. Thank you.
All right, you're welcome. Thank you.
Yes, sir.
Yes, sir.
How you doing, Your Honor?
Doing pretty good. Mr. Jackson. All right, you're charged with one count of theft by receiving stolen property. Your bond is 8,000. Your special condition is that you have no contact with Chiquita Renwhite. And your preliminary hearing is the 12th of September at 8:30. And I am appointing an attorney to represent you, sir. You have any questions?
Your Honor.
All right, thank you, sir. Yes, sir. Good morning. What's your name?
James Kenner.
All right, Mr. Kenner, you're charged with 2 counts here, possession of firearm by a convicted felon and altered ID mark. It is 5,000 on each of those 2 offenses, 10,000 total. Preliminary hearing is the 12th of September at 8:30. And I will appoint an attorney to represent you, sir. You have any questions?
Your Honor, thank you very much.
Yes, sir. Thank you.
Have a good day.
You too.
Hi, good morning, sir.
Yes, sir. Good morning. What's your name?
Austin Bullock.
All right, Mr. Pullick, let's see, charge of 1 count of improper lane change, 500 criminal damage to property, 2nd degree. That's a felony, 2,000. Contributing to delinquency of a minor, 5,000. You have a preliminary hearing scheduled for the 12th of September at 8:30. And I am appointing an attorney to represent you, sir. You have any questions?
What was the last one?
4,500 is your total.
Okay.
Yes, sir. All right.
Thank you.
All right, you're welcome. Thank you. Yes, sir. Good morning. Oh, good afternoon. What's your name? Good morning.
Chris Romero.
All right. All right, Mr. Romero, you're charged with 1 count of, well, you're a fugitive. All right. Are you're Christopher Romero?
Yes.
All right, sir. So the Constitution and rights I read earlier, they all apply to you. However, you're here for the beginning, the phases of an extradition proceeding. Sir, this is pursuant to Georgia law related to the warrant that is appearing before me here says that you did enter and remain in the state of Georgia. No, you're wanted out of Florida, Washington County Sheriff Office for probation violation. It's a felony and they will extradite. So what's happening today, because it's a felony, I can't give you a bond by law here because you're considered what's called a flight risk. You're from out of state. So there's no bond. You have to talk to your lawyers. 2 things happen today. You can either waive the formal extradition proceedings or you can contest the proceedings, meaning if you contest the proceedings or fight it, you will get a chance to contest 4 things. 1, whether the charge or charges are valid on its face. 2nd, whether you are in fact the person named in the warrant. 3, whether the charge is actually illegal in the state of Georgia. So those are the things that you can contest or fight. You can also contest if the charge is actually still a valid charge or not. So outside of those things, you can contest here in Georgia. You can contest here in other ways. So what's happening is if you waive, then generally the other location, so Florida, they will have 10 days generally to pick you up, but they can take longer. They can get an extension. If you don't waive and you wish to fight it and have the formal hearing, it's 30 days usually, but it can be an extension up to 90. So at this time, what is your preference? Do you wish to waive the formal proceedings and go back to Florida, or do you wish to fight it here in Georgia? Mr. Romero. Waive. All right. So I sent over the forms, so you should have them there, or the deputy should have them. And thank you very much. If you can complete all of them, and do you have any questions, Mr. Romero?
Oh, I'm sorry.
You have any questions before you sign those? No?
I'm kind of confused what's going on for real.
All right, what's your question then?
I actually was on probation in Clayton County, so I don't charges.
Yeah, that I don't know. That I can't answer for you. So just speak with the lawyer and see what they can tell you about that.
All right.
All right, yes, sir. All right, thank you. All right, yes, sir. Good morning. What's your name?
How you doing? My name is Joel Sanchez.
All right, Mr. Sanchez, I'm doing good here. You charged with one count of driving on an expired registration. Your bond is $500. Driving while license suspended, $1,500. Preliminary hearings the 13th of August, 8:30. One moment, I'm sorry. The 13th of September at 8:30. And I am appointing an attorney to represent you. Mr. Sanchez, you have any questions?
Yes,
Yes, sir.
to try and request ROR, who do I speak to you now or my lawyer?
Yes, sir. So at this time, you're not getting an ORA bond from me. So speak to your lawyer, and your lawyer can take it from there.
All right, thank you. Appreciate it.
Yes, sir. Thank you.
Yeah, I'm the Demontavious Snyder.
All right, yes, sir. Mr. Snyder, good morning to you. You're charged with aggravated assault, possession of a weapon during the commission of a crime, and malice murder. There's no bond on any of those offenses. There's something an attorney to represent. Well, you refuse counsel, sir. Your preliminary hearing is September 12th, and your bond hearing is September 13th, both days at 8:30. Do you have any questions, sir?
If I was to get a lawyer, do I still can I get a lawyer for that?
Yes, sir. All right. Yes, sir. Thank you.
I think. Good morning, Your Honor. My name is Marlon Stevenson.
Good morning to you, Mr. Stevenson. So you're charged with, one moment here, one count of battery, one count of aggravated battery, one count of aggravated assault by strangulation, one count of false imprisonment. So there's no bond on those offenses today, sir. September 12th, 8:30 is your preliminary hearing, and I will appoint an attorney to represent you. Do you have any questions, sir?
No, Your Honor. Thank you.
All right, thank you.
My name is Kyle Stowe.
All right, Mr. Stowe, sir, you're charged with criminal damage to property, second degree. 2,000 is your bond.
Yes, sir.
All right, let's see. September 13th at 8:30 is your preliminary hearing, and I will appoint an attorney to represent you, sir. You have any questions?
Sir, thank you.
Yes, sir. Thank you.
Good morning, Your Honor, Cedric Vaughn.
Yes, sir. Good morning to you, Mr. Vaughn. So you're charged with one count of theft by receiving stolen property, 2,000 is your bond. Concealing the ID of a motor vehicle, 500. Driving motor vehicle with invalid registration, 500. Preliminary hearing is the 12th of September, 8:30. And I will appoint an attorney to represent you, sir. You have any questions?
Yes, sir. How much is that total?
3,000.
Yes, sir. All right. Thank you, sir. I appreciate it.
Yes, sir. Thank you.
Have a good day.
You too.
All right, Judge, that will be everybody for today.
All right, appreciate you. Thank you very much. We'll see you soon.
All right, have a good day, Jordan.
You too. Thank you. All right, bye.
Looked at this warrant number and the case number, and I'm not seeing anything within this arrest affidavit that indicates that there was some sort of violation of a domestic injunction.
Does it say when the warrant was signed?
I looked up the case case number, and the last thing that's in there was from
Oh.
July 29th.
I signed this warrant. This name sounds familiar. I signed the warrant. It was allegations of, I believe, text messages. I remember the name. So, Mr. Callahan, I'm going to appoint the Office of the Public Defender to represent you. There has been a previous probable cause determination. And counsel, could you just mute your mic again real quick? Thank you. There has been a probable cause determination as to the violation of the domestic injunction. It says he does qualify for PTR with a bond, correct?
Yes, Judge.
All right, the victim's also indicated she does not wish to have any contact. Mr. Callahan, no contact means no contact. I'm going to set bond at $500. So you will get a bond as this charge with the understanding that there is a no contact order in place. If no contact means no contact, it means no text messages, phone calls, emails, no contacts through third party, until further order of the court. You understand?
Yes, sir, Your Honor. I have a question
Oh.
for you, sir.
Hold on real quick. I've appointed an attorney to represent you. Anything you say can and will be used against you. The only thing we're doing here today is setting conditions of release. You're free to ask a question. I just want you to understand that in most instances of this first appearance, anything you say is probably not going to help you, and most times it comes back to bite you. So I'm just telling you to help you out. Knowing that, though, you can ask whatever you want. What would you like to ask?
Your Honor, according to what you just said, you said something about a text message. Texted or whatever, I haven't contacted this individual. Within the last 2 weeks, I done had like 3 episodes of rhabdo and rheumatoid arthritis where I done been in the hospitalized. And this individual has popped up at 3 Winter Garden Hospital.
Sir, hey, sir, I'm going to stop you right there just because I don't want you to say anything that's going to come back to bite you, okay? You have a bond. Well,
It can't bite me, Your Honor, because the simple fact of I
Well,
was
listen.
hospitalized and they popping up at the hospital and I'm not calling them and they just showing up and they signing in themselves.
okay, well, I understand. Listen, I used to be a criminal defense attorney. I'm telling you that what you say here today is just, all we're doing here today is setting conditions of your release. You're getting a bond. Today's not your trial. I've reviewed the affidavit that was filed to issue the warrant. I found there was probable cause. That doesn't mean that I have to take everything in the affidavit as true. Whether it's true or not, I have to consider it true for today's purposes only, okay? So I'm setting a bond. I'm just going to require you to have no contact with the alleged victim. If you're not having contact with her, that's great. Continue having no contact, but that's going to be a condition of your bond, okay?
There was no possession.
And no possession of any weapons, all right? But you do have a bond, $500. Thank you, sir.
Thank you, Your Honor.
All right, Maurice Crane. All right, Mr. Crane, you're here on 1 count of aggravated battery, great bodily harm. I've reviewed the affidavit, do find there is probable cause. I will appoint the Office of the Public Defender to represent you. Bond will be set at $7,500. You have no contact with the alleged victim, possess no weapons, and that'll be conditions of your bond, okay? Thank you, sir. Fernando Gonzalez.
Your Honor, he does require the services of a Spanish interpreter.
All right, is he the only one?
I have one more, Your Honor.
All right, we're going to call the interpreter.
morning, Your Honor. This is the Laura Bretaña, Spanish interpreter. The interpreter has not been sworn.
You have not been sworn?
No.
All right, would you please raise your right hand to be sworn, Madam Interpreter? Do you promise to translate from English to Spanish and Spanish to English the testimony you will hear today to the best of your ability?
Yes, I do. Laura Bretaña, certified Spanish interpreter.
All right, we have one gentleman, well, I think we have two people who need the services of the Spanish interpreter that are in Osceola County. The first is Mr. Gonzalez Perez. Sir, what is your name?
Señor, ¿cuál es su nombre completo? Fernando González Pérez.
All right, sir, you're here one count of DUI.
Señor, usted se encuentra aquí acusado por un cargo de conducir bajo los efectos.
The courts reviewed the charging affidavit, does find there's probable cause.
Habiendo repasado el documento acusatorio, se determinan que existen indicios de criminalidad.
I will appoint the office of the public defender to represent you.
Se designa a la oficina del abogado de oficio para que les represente.
And will stay the bond at $500.
La fianza permanece tal cual, $500.
Thank you, sir.
Gracias, señor.
This is a charge that would qualify him for direct PTR, but there's some sort of immigration issue. Defense would ask for ROR on this.
Su señoría, esto es para información del juzgado. Él cualificaría, según la acusación, para que se le conceda la libertad a través del programa de libertad provisional, pero hay unos asuntos con inmigración, así que se ha solicitado que se le conceda caución juratoria.
All right, the court will grant ROR with the following conditions.
Muy bien, entonces se concede caución juratoria con las siguientes condiciones.
Maintain contact with your attorney.
Se tiene que mantener en comunicación con su abogado.
And you consume no alcohol.
Y se le prohíbe el consumo de alcohol.
Okay?
¿Está bien?
All right, thank you, sir.
Gracias, señor.
All right, Charles Jones.
Your Honor, I have one more interpreter.
Oh.
That's Gustavo Verde Gutierrez.
Yes, I'm sorry. Mr. Jones, please have a seat. We're going to take the other interpreter while we have the interpreter here. Thank you. All right. Sir, what is your name?
Señor, ¿cuál es su nombre completo? Gustavo Verde Gutiérrez. Correct.
All right, sir. You're here on one count of domestic battery by strangulation.
Señor, usted se encuentra aquí ante una acusación de agresión física por violencia doméstica, estrangulación.
Court has reviewed the charging affidavit, does find that there's probable cause.
Habiendo repasado el documento acusatorio, se determina que existen indicios de criminalidad.
I will appoint the office of the public defender to represent you.
Se designa la oficina del abogado de oficio para que les represente.
I do see that, like the gentleman before you, you would qualify for pretrial release other than your immigration status.
Veo que al igual que el caballero que atendimos antes que usted cumpliría con los requisitos del programa de libertad provisional si no fuese por el estado migratorio.
Given the allegations in the arrest affidavit, however, the court's inclined to set a bond.
Pero debido a las acusaciones que constan en el documento acusatorio, este juzgado se inclina a conceder una fianza.
The conditions of your bond, and I'll set bond at $500.
Se concede fianza por la cantidad de $500 y las condiciones de la misma son:
Conditions of the bond that you have no contact with the alleged victim.
Como condición de la libertad se le prohíbe todo tipo de contacto con la víctima.
That you possess no weapons.
Se le prohíbe la tenencia de todo tipo de armas.
And that you do not return to the residence.
Y se le prohíbe regresar a la residencia.
I will allow you to return to the residence one time under the accompaniment of law enforcement.
Le voy a permitir que regrese a la residencia en una ocasión acompañado de las autoridades
To retrieve any personal belongings.
para que recoja sus pertenencias.
Other than that, you're not to be at the residence.
Aparte de esto, se le prohíbe estar en la residencia
and are to have no contact with the alleged victim
y se le prohíbe todo tipo de contacto con la presunta víctima
until further order of the court.
hasta que un juzgado ordene lo contrario.
All right, thank you, sir.
Gracias, señor.
Your Honor, one more has indicated that he needs the services of the Spanish interpreter, Jorge Rivera Torres.
Okay. All right, sir, what is your name?
Buenas tardes, señor. ¿Cuál es su nombre completo? Jorge Rivera Torres.
All right, Mr. Rivera Torres, you answered my question without waiting for the interpreter. Do you understand English?
Señor Rivera Torres, usted contestó.
I'm just going to ask him in English, Madam Interpreter, then we'll see if we
Yes.
need you, okay? All right, sir, you answered my question in English. Do you need the services of the Spanish interpreter?
Yes,
All right, so you don't speak and understand English?
I understand, but not a lot.
Okay, all right, well, we'll go ahead and proceed with the services of the Spanish interpreter. You're here on 2 counts, 1 count of false imprisonment and 1 count of domestic battery.
Señor, usted se encuentra aquí ante 2 cargos, uno de restricción ilícita de la libertad y otro de agresión física por violencia doméstica.
The court's reviewed the charging affidavit does determine there's probable cause as it relates to both counts.
Habiendo repasado el documento acusatorio, determinó que existen indicios de criminalidad para ambos cargos.
I'll appoint the office of the public defender to represent you.
Se designa la oficina del abogado de oficio para que les represente.
And I do see you qualify for pretrial release with a bond.
Usted cumple con los requisitos para que se le conceda libertad a través del programa de libertad provisional con fianza.
I'm going to set bond at $500
La fianza será de $500
and order you on pretrial release
y se le ordena que participe del programa de libertad provisional.
with the following conditions: that you do not have contact with the alleged victim,
Con las siguientes condiciones, se le prohíbe todo tipo de contacto con la presunta víctima,
that you possess no weapons or ammunition,
se le prohíbe la tenencia de todo tipo de armas y municiones,
and that you do not return to the residence
se le prohíbe regresar a la residencia.
If you need to return to the residence one time, you may do so under the accompaniment of law enforcement.
Si necesitara regresar a la residencia, podrá hacerlo en una sola ocasión acompañado de las autoridades.
And the purpose of that one-time return is only to retrieve any personal belongings.
Y el propósito de esa visita es de recoger las pertenencias.
Other than that, you may not return to the residence until further order of the court.
Aparte de esto, se le prohíbe regresar a la residencia hasta que un juzgado se lo permita.
All right, what's that?
It's 2 counts.
The bond amount was set on count 1. On count 2, the battery count will set bond at $100.
La fianza que se mencionó era para el cargo número 1, para el cargo número 2, la agresión física, la fianza son $100.
All right, thank you, sir.
Gracias, señor.
All right, Madam Interpreter, that's it for Osceola. We'll probably give you a call back here in a few, okay?
Thank you, Your Honor.
All right, thank you. All right, Charles Jones.
Your Honor, I do have a PC argument as to the duelists.
All right, so Mr. Jones, you have 2 cases. You have 1 case with 2 counts, 1 possession of controlled substance being cocaine, 1 possession of drug paraphernalia. You have another case. It is a drum while license suspended as habitual offender. Counsel, I'll go ahead and appoint the Office of the Public Defender to represent you in both cases. Counsel, if you want to go ahead with your probable cause argument as it relates to the duellists.
Your Honor, there's nothing that indicates within the charging affidavit that he has been designated as a habitual offender. Further, there's nothing in here that indicates that he had knowledge that his license was suspended.
Say, I do see prior Dwillis convictions, but they're all outside of 5 years. And I don't see where he was otherwise designated habitual traffic within. Do you have any argument as to, I do find PCS to driving while license suspended with knowledge. But as to the habitual designation, state.
State agrees, Judge.
All right, so we'll find probable causes to driving while license suspended with knowledge, but without the habitual offender status. We'll set bond on that count at $500.
Your Honor, all of these are eligible for direct PTR?
Okay, I do see that. All right. Court finds probable cause as it relates to the drug counts too, both counts 1 and 2 in that case. It is eligible for pretrial release. Court will place you on pretrial release. That's a non-monetary release, but there's some restrictions. It's kind of like being on probation, okay? A special condition of that probation, or it's not probation, pretrial release, is going to be that you do not operate a motor vehicle without a valid driver's license, okay? All right.
If I go get my license, I'm good, right?
Yeah, it couldn't hurt to get a valid driver's license, but a condition of your bond is going to be until you have a valid driver's license, you're not to operate a motor vehicle. That's going to be a condition of your pretrial release. So if you do get caught, you're going to be brought back, and then you won't be entitled to a bond. So it's very important you don't drive without a valid driver's license. Okay. All right. Good luck to you, sir. That was Charles Jones. All right. Lewis Michaels.
For the court's information, he is eligible for direct PTR.
All right, thank you. All right, sir, you're here on one count of grand theft greater than $750. The court's reviewed the charging affidavit. Does find there's probable cause. You do qualify. I'll appoint the Office of the Public Defender to represent you. You qualify for pretrial release. The court will order you to pretrial release. Say, I'm not going to order him not to return to the 7-Eleven given the nature. It looks like the allegations are that he took a wallet from a customer in front of him. He didn't take anything necessarily from the 7-Eleven unless you have a reason for me to order him not to return to the 7-Eleven.
The state has no input on that, Judge.
Okay. All right. I'm not going to order you to not return to the 7-Eleven, even though that's where it took place because the crime wasn't committed against the 7-Eleven or alleged to have been committed against the 7-Eleven. So that's not going to be a condition of your pretrial release. All other conditions of pretrial release will apply. Thank you, sir. Hector Morjan.
And Your Honor, is a victim.
All right. All right, ma'am. What is your name?
Ashley Reynoso.
Speaking to the microphone, I can't hear you.
My name is Ashley Reynoso.
Okay. Are you the alleged victim in this case?
Yes.
All right. All right, sir. I'm going to ask you some questions in a second. I'm going to talk to him first. All right, sir. You're charged with 2 counts. 1 count of hindering communication with law enforcement. 1 count of battery, touch, or strike. The court's reviewed the arrest affidavit. Does find there is probable cause as to each offense. I'm going to appoint the Office of the Public Defender to represent you, and I'm going to hear from the young lady who is here before I determine conditions of your release, okay? All right, ma'am. The purpose for today's hearing is to determine conditions of release. He's entitled to a bond. I'm going to set a bond, but we can put certain conditions on it. If you don't wish to have contact with him, I can order him to have no contact with you. I can order that you guys maintain separate residences, hold on one second. So let me ask you, do you want to have contact with him?
No.
No? Okay. Are you two living together?
He has residency because he has belongings there, but he's not on the lease.
Okay. So So I can order him, I can allow him to come back to the residence one time with the in the presence of law enforcement. Okay, so he would have to, if he's going to come back, he has to call the cops first and come there with the police to get his belongings. Or you can set him outside and he can get him whatever, you know. But do you want him to come back even with law enforcement? What belongings does he have there? Let me ask that.
It's just clothing and shoes. His kids have clothing and shoes as well, but they told me, I don't know if he communicated with them, but he told me, his brother-in-law told me to pack all the kids' stuff today so they can get it. And then I said, what about your stuff? And then he told me that he's going to come back with law enforcement. But if I can just give them everything, I'd rather just get that step out of the way.
So you can give it to his brother-in-law?
If he allows me to give it to his brother, I'll just give him everything.
Okay, well, here's what I'm gonna do. I'm not gonna allow you to return to the residence even with the presence of law enforcement. I'm gonna, until further order of the court. You can give this.
Sir, can I please say something, sir?
I'm not gonna allow you to say, I'm gonna finish what I'm gonna say, and then I've appointed the Office of the Public Defender to represent you. I would advise you strongly to, anything you want to say, that you run it through your attorney. Sir, your microphone's muted because I'm still talking. I'm talking to the young lady, okay? All right. I'm going to order that you have no contact with the alleged victim in this case, that you possess no weapons, that you do not return to the residence until further order of the court. Counsel, do you wish to be heard on the one-time return?
Your Honor, defense would ask at this time that he be granted a one-time return with law enforcement. His children do reside there and they have belongings there, just to make sure that everything is collected and taken from the residence.
Okay, hold on, sir. Sir.
I'm sorry.
Yeah, thank you. I am going to allow him to return one time. Yeah, well, go ahead, ma'am.
So I don't mind if he returns with law enforcement. I just need an advance notice.
That's how it works.
I'm registered with the Department of Children and Families, and I run an in-home daycare, so I can't just have him popping up.
It's not going to happen that way.
Okay.
So now I need you both to listen. Sir, I need you to just listen. Stop being so animated. Listen, I don't want to hear it. Okay? We're here on a very limited purpose today, and I don't need you, doing whatever you're doing. It's very distracting to the court, okay? All right? So, I'm going to allow him to return with law enforcement one time. So I just need you to listen up.
So I don't give his belongings to his brother-in-law today? Because he was asking for his kids, and now he's saying he needs a U-Haul.
This is what I'm going to do. If you want to give him to his brother-in-law, you can do that. I'm going to allow him to go back to the residence one time in the presence of law enforcement. And the way that works, sir, I need you to listen. The way that works is that you call the law enforcement first. Do not show up there and then call the cops. You call the cops first and say, I've got a court order that I need to go back and get my personal belongings, and then you show up with law enforcement. They will coordinate that with the alleged victim, and that's the only time you can return. Other than that, you're not to return to the residence other than that one-time return. I'm also was there alcohol involved in this, or no? All right. So I'm also going to order that you possess no weapons and that you have no contact with the alleged victim. No contact means no contact. That means no third party contact, no communication through the kids, no text messages, emails, Instagram, TikTok, anything like that.
All right, sir.
Yep.
Now, when it comes back to going to the house, do I have a time limit? Because I got to bring a U-Haul because I got a lot of belongings there. I live there. Everything in my possession, everything that's mine is there at the house. So I need to grab everything. With her, she's making it seem like I don't live there. So,
I didn't say that.
All right.
All you have that's big as beds. You don't have a couch.
Listen. We're not going to get it. Whatever you need to get, if you need a U-Haul pickup truck, I don't care.
Me neither.
You do whatever you got to do, sir. You can only go back one time with the presence of law enforcement. If that one time you have a U-Haul, a semi-trailer, I don't care what it is. You can get whatever. You can go back one time. You can't make multiple trips. It's a one-time trip. All right? So, that being said, you just got to coordinate that with law enforcement. Did I set bonds 500? I didn't. All right, so I'm gonna set bond at $1,500. $1,500 gonna be your bond with those conditions, all right? $1,500 on the hindering communication with law enforcement and $500 on the battery. Thank you, sir. Good luck. Thank you, ma'am. Thank you. Yeah, do you have something else you want to say? Okay.
I just wanted to know if I have, like, is there an injunction or a restraining order?
It's a no contact order. If he has any contact with you, you can call the police.
For how long?
Until further order of the court. But if he has any contact with you, through third parties, through the kids, anything like that, you can call the police and they'll be picked up, okay? All right. Tommy Wood. All right, Mr. Wood, you're here on a violation of probation warrant. Came in at no bond. I'm going to appoint the office of the public defender to no, it is a bond. There is a bond. $1,500. The court's going to stay the bond at $1,500. I'll appoint the office of the public defender to represent you, okay?
Thank you, Judge.
All right, and then we have the two reset from yesterday, Pierre Evans.
Your Honor, just for the court's information, this is a charge that would be eligible for direct PTR. There seems to be some sort of issue in benchmark that's showing he has an open case. However, he pled to that case on September 13th, credit time served of 2021. So we would ask for ROR.
All right, let me review the affidavit real quick. I'm going to appoint the office of the public defender to represent you. I think I did yesterday. State any objection to ROR with the no return to the Wawa? It's just, I mean, it's a trespass.
Yes, Judge, the state would object. He has an incredibly lengthy history. I mean, it looks like 35 different cases in Osceola County alone.
All right.
He has indicated that that history is mostly crimes that are usually associated with, poverty,
Right.
gangs, transiency, like trespass and personal use possession.
State, is that your understanding? I understand it's lengthy, but is it mostly trespass and drugs?
Multiple theft convictions, Judge, criminal mischief convictions, sale and delivery of cocaine. But the vast majority of it is what defense has described.
All right, sir. I'm gonna ROR you with the condition you do not return to the Wawa. If you return to the Wawa and they call you, you can be picked up and be held no bond. Do you understand that? All right. Thank you, sir. All right, Kinzel Vargas Cespedes.
And for the court's information, these are eligible for direct PTR.
All right. All right, sir. You're here on one false ID given to a Leo and trespass after warning. I do find probable cause. I think I've already appointed the office of the public defender to represent you. You do qualify for a pretrial release. I will grant pretrial release with the special condition you not return to the Wawa at where this was alleged to have occurred, okay? If you return to the Wawa and they call the police and you're there, your pretrial release will get revoked and there's a chance you're held no bond, okay? All right, good luck to you, sir.
Thank you, Judge.
All right, is that it?
That's it for Osceola.
All right, thank you very much. Good to see you.
Yes, sir. Next time.
Yep.